I'm Ankit Mishra, and I and Shubha will be the court masters for today's proceedings. Now, I would like to request the counsels for the claimant to please tell their names and the time allocation for their team members.
The claimant speaker 1 is Kavya Agarwal, and I will be speaking for 13 minutes. Claimant speaker 2 is Ikjot Dang. Ikjot Dang, and she will be speaking for 10 minutes.
Okay.
We will be reserving 2 minutes for rebuttals.
Then what would be the time for researcher?
Yes, 1 minute out of that 2 minutes for rebuttals.
Okay.
Thank you.
Can I request everyone to keep their mobile phones off?
Yes, ma'am. May I ask teams to put the time allocation in the chat box, please? For the judges' convenient.
Are we live now already?
Yes, ma'am.
Okay.
Now, I'd like to request.
I can see Professor Hegde. Good morning. You're muted, Professor Hegde. You're muted.
I also welcome you, madam. Thank you very much.
Good morning.
Yeah.
The third judge is Mr. Khanna is not there, so it's Dr. Kumar Abhijit, isn't it?
Yes, ma'am.
Okay, perfect. So after the session, we can have our separate interaction later. The two judges and us the three of us will have separate interaction after the sessions are over. So let the other two speakers also introduce themselves, and then the claimants can start.
Okay.
Good morning, ma'am. I am speaker number 1 from the responding side, and I'm Shovit, and I've been going to take 9 minutes. And speaker number 2, Mr. Uditanshu.
Yes.
He is going to take 14 minutes.
Who is the second speaker? Can you raise your hand? Yeah.
Madam Honorable Justice, I am the second speaker.
Okay. Okay.
My name is Uditanshu, and I'll be taking 14 minutes.
14 minutes.
Yes. 1 minute is reserved for sir rebuttals, and 1 minute for researcher.
Okay. Thank you, guys.
All right. So if the court masters are ready, we can start with the first speaker.
Yes, ma'am. Now, if it may please this honorable tribunal, should we start with today's proceedings?
Yes, please.
Madam President, members of the tribunal, good morning. My name is Kavya Agarwal, and I, along with my co-counsel, Ms. Ikjot Dang, shall be representing the claimant in the matter of Supreme Manufacturing Limited versus Peterson Backer Power Generator Co. The present dispute before the tribunal has arisen pursuant to the contract dated 10th May 2015, which provided for the delivery.
I think all of us are familiar with the facts, so I think we can save on the facts.
Okay, yes. The disputes between the parties have raised three principal questions for the consideration of this tribunal. First, whether there has been a breach of contract by the respondent. Second, whether claimant is liable to compensate respondent for alleged expenses incurred in the preservation, repair, and sale of the first unit delivered. And third, whether damages are liable to be paid by either party in the context of the performance or non-performance of obligations under the contract. With your permission, Madam President, I seek to move on to my submission for the first issue.
Yes, please. Move on.
We submit that the respondent has committed a breach of its obligations under the contract dated 10th May 2015. In this context, the claimant shall further 5 broad submissions. First, that the respondent failed to issue a specific notice of non-conformity. Second, that even if such notice was issued, the respondent failed to do so in a reasonable time. Third, in the event of non-conformity, The claimant retains the right to determine the approach to be adopted for remedying the alleged defect. Fourth, that the respondent has no justifiable basis to avoid the contract. And fifth, that the respondent's failure to pay for the first unit amounts to a fundamental breach of the contract. At the very outset, we feel it prudent to clarify a few of the points in this case for the benefit of the tribunal. The preliminary clarifications clearly state that if the claimant is a Monsantanian company, which it is, then the arbitration shall be conducted under the international arbitration rules of the American arbitration. It is submitted that as this is institutional arbitration, therefore the International Center for Dispute Resolution is the appropriate forum for this dispute, as it is the international division of the American Arbitration Association, as otherwise held by the respondent. As per the facts of the case, we submit that the respondent failed to issue any specific notice of non-conformity. In this context, we seek the indulgence of the tribunal as we highlight certain pertinent facts. Under the terms of the contract, the claimant was required to deliver the first unit within 5 months. This obligation was fulfilled by the claimant.
Counsel, don't you think when you look at Exhibit 3, it shows a kind of panic at the end of Peterson when they wrote to you saying that, we're having difficulties in getting the unit to work itself. We'll let you know more soon. And then you simply ask them, what is the nature of the difficulty? And then you ask them, is the unit operating? But then they tell you something important. Automatic alternator system is not functioning. Isn't that like the main part of your generator? And if that's not functioning, you cannot expect the buyer to keep listing out issues and do everything when they are kind of already in a state of panic when your equipment is not working properly.
Madam Counsel, Madam President, the Council would like to state that if we look at these mails, it clearly demonstrates that none of these communications specifically address any issue of lack of conformity. The notice under Article 39 requires that the notice of non-conformity has to specify the precise nature of the defects, and that the notice must give a complete picture of the examination of the goods.
How do you read Exhibit 7?
Exhibit 7, yes. Yes, so Exhibit 7, it states that we do not have personnel available. The second half of Exhibit 7 states that we do not have personnel available to diagnose further. Please repair promptly.
But do you understand the meaning of automatic alternator system does not function?
Yes, we do.
That's like saying an engine in the car does not function.
Yes. However, the fact that they also stated that there is a possibility of further non-conformities existing in the alternator unit left the claimant unclear about whether it should send the personnel to diagnose the further defects or should it send the personnel to repair the existing defects, and therefore because of lack of clarity.
Can you support your argument with some case law?
Yes, definitely. It is submitted as according to Cloud Case number 938 of 2007. The buyer must specify the precise nature of the defects. And according to Cloud Case number 721 of 2006, it is held that general complaints like not all right, inadequate characteristics, wrong delivery, poor quality, as well as general statements of dissatisfaction is not enough to take recourse to remedies available for lack of conformity. This case also lays down that the burden for proof for lack of conformity and the requirements of notice lies on the buyer and not the seller in this case. Therefore, intervention by claimant is only mandated in circumstances where a specific notice has been issued identifying the non-conformity, and as in this case, on account of the fact that there was no specific issue, it is submitted that the respondent has waived the right to claim lack of conformity.
Okay, please proceed further.
Thank you. Now, even if this tribunal finds that the respondent had given the claimant specific notice of non-conformity, our second submission is that such notice was not issued within a reasonable time by the respondent. Here it becomes relevant to note that the first unit arrived at the port in Atlantino on 21st October 2015. Thereafter, notice of the impending delivery was issued on 11th October itself, so that the respondent may make any necessary arrangements to receive the delivery. Even if it is considered that the notice of non-conformity was sent on 22nd November, it is 32 days after the unit was delivered by the respondent. This amounts to more than a noble month, which is the period of time identified as reasonable under the scope of Article 39(1) of the CISG for communication of non-conformities. Therefore, we submit that the respondent failed to exercise the necessary due diligence with regards to their performance under the contract, and therefore the respondent's notice was not in compliance with reasonable time under the standard of Article 39(1) of the CISG. Now, if the tribunal finds that the claimant has delivered non-conforming goods, our third submission is that the claimant has the right to decide which remedy they want to apply. In this regard,
if there is a fundamental breach, like the machine not working, will the rule of noble month apply?
Madam President, the council would like to argue in one of the further arguments that sending of non-conforming goods was not a fundamental breach committed by the claimant.
Okay.
To pursue this argument, the council would like to state that it is rather the respondent's failure to pay for the first unit that has led to a fundamental breach of contract. It is submitted that to establish a breach of contract, 2 points need to be proved. First, substantial detriment, and second, foreseeability of the detriment cost, which have not been done by the respondent in both the cases. It is submitted that clause 7.1 of the GCC requires payment of each shipment be due within 30 days, and the same was not complied by the respondent in this case, which led to the claimant suffering substantial monetary losses. First, with regards to the payment of the first unit shipped, and second, the loss of the profit of the remaining 5 models which were a part of the contract. Moreover, Madam President, the council would like to state that respondent has had no grounds for seeking the avoidance of contract, as under Article 49, avoidance of contract is considered a remedy of the last resort that is available when the buyer can no longer be expected to continue the contract. In the commentary by Peter Skellstream and Cloud Case number 152 of France, it was held that to the extent that the defect can be rectified and where the seller has offered to remedy the defect within reasonable time, avoidance because of fundamental breach will not be a remedy available to the buyer, even in the case of a serious breach. It is also held that according to Article 47 of the CISG, until and unless the seller
But the problem here is they ask you to depute your personnel, which you completely and refuse to do that. And if they don't have the wherewithal in terms of the personnel, you cannot expect that there is no breach by you by not sending the personnel.
Madam President, it was clearly informed by the claimant that sending personnel to repair this would amount to unreasonable costs on by the claimant, and therefore it is better if they find personnel. They are a company that are involved in the servicing of generator backup power units. It is unreasonable to believe that they did not have personnel to repair a good that forms the very basis of the job that they do. Here, the council would like to point out that from the very beginning, the intention of the respondent was to avoid the contract. Even before sending the first notice on 9th November, they clearly had gotten into a contract with the third party, North Nest Manufacturing, for the same contract at a less price. Therefore, the entire
What is the date of that contract? What is the date of that contract?
It is mentioned on Moot proposition page 2, where they state that they entered into a contract with the third party, North Nest Manufacturing, who was
on 9 November. So the first email was also 9 billion.
Exactly.
All
So
right.
therefore, the claimant alleges that all of the procedures and the performance of the contract for the entire time was just a ploy to avoid the contract by the respondent, because they had already found another buyer for the same, and therefore they wanted to avoid the contract. If Madam President allows, the council would like to take 1 minute to submit for the second issue before.
Yes.
Thank you. It is submitted that the claimant is not liable to the respondent for expenses incurred in preserving, repairing, and selling the first unit because, on account of fundamental breach caused by the respondent has forfeited its right to, first, the right to claim damages under Article 45(1). Second, their right to require delivery of substitute goods or repair them under Article 46. Third, their right to declare the contract avoided under Article 49, and their right to reduce the price of goods under Article 50. Therefore, the forfeiture of the right to avoid the contract has consequently resulted in their consequent relinquishment of the right to preserve the goods delivered or sell the goods they have preserved. Also, their failure of providing a notice under Article 39(1) requires them to retain the goods regardless of whether the unit was non-conforming or not, and therefore they are required to pay the price of the good in spite of the alleged non-conformity. And thank you.
I just want to ask one question, if there is a Madam President is permitted.
Yes, please. Yes, Professor.
Yeah, I just want to ask you, in case if you don't send your personnel to look at the product or the material you have supplied, how would you know that that material is defective? How do you confirm it? You know, you said that on a second email, you stated that you are sending a new product altogether and that you keep this. So now, without having the verification as to how the product which you have sent, and as a respondent very allegedly claims that this is a defective product, but how do you actually ensure that without proper examination, without proper assessment, and then you reach a conclusion stating that whatever the respondent is doing is actually defective. So don't you think that it actually will act as a mitigating factor for the respondent to claim damages?
The arbitrator, the council would like to further two arguments with regards to this response, with regards to this question. First of all, because of the 10-year long-standing business relationship between the parties, the claimant acted in good faith to hold that yes, the information of the non-conformity delivered by the respondent must be correct, and that is why we immediately sent, on the very day we sent, a substitute good for the same. However, in accordance to clause 9.5 of the general conditions, it is the claimant who holds the right to decide which remedy to provide to the respondent in case the goods are non-conforming. And in this case, the claimant decided that sending substitute goods would be more reasonable as per the cost and convenience, and therefore we acted on the same and delivered it by the air within 2 days. However, this act of done in good faith by the claimant was not respected by the respondent, and they refused to accept our remedy of the goods provided.
Okay, continue. Yeah, fine.
Thank you.
Number 2, please.
Yes, thank you. It was an honor speaking before this tribunal.
Madam President, members of the tribunal, good morning. My name is Ekju Dang, and I am the co-counsel appearing for the claimant, Supreme Manufacturing Limited. Today, I shall be addressing the third and the final issue pertaining to damages in costs arising from the contract dated 10th May 2015. As a part of this issue, I have 3 broad submissions. First, that the respondent should be liable for the damages for the breach committed by it and the failure of the payment for the first shipment. Second, that the claimant is not liable for any damages to the respondent on the context of the delay caused to Atlantino Construction Company, which is the respondent's sub-buyer in this case. And third, that the claimant should be liable to pay all costs of arbitration and the lawyer's fee for the dispute arising in this question. If there are no preliminary inquiries, Madam President, may I please move on to my first submission?
Yes, please.
Thank you. Members of the tribunal, we submit that the respondent is liable to compensate the claimant for the damages arising out of their breach of the contract on 10th May 2015. At the very outset, it is relevant to note, as my co-counsel has already argued, that the claimant has committed a fundamental breach of the contract by avoiding the contract. In this context, the loss of profits suffered are liable to be recovered under Article 74 of the CISD. Article 74 of the Convention deals with damages as a consequence of breach, and it states that the damages given under this provision should not exceed the amount that the breaching party foresaw or ought to have foreseen. This makes the respondent liable for first $100,000 with an interest at the rate of 6% for the first unit that was shipped, and second, $100,000 with interest for the loss of profit suffered on the 5 units that were cancelled by avoidance of this contract.
Counsel,
Article 62.
Counsel, in this case, I think you are double claiming. If you look at your Exhibit 18, the 3rd July 16 email, you only said that as a final settlement, you only wanted 100,000. So why has it now become 200,000?
Madam Arbitrator, I would like to state that this negotiation was a part of the good faith shown by the claimant. However, as the respondent has not responded to such requests made by the claimant had no other option but rather choose for invoking arbitration in this case. And therefore, now we are also claiming our lost profits for the 5 units that were not shipped and cancelled by the avoidance of this contract.
Yeah, but you cannot double your claim immediately, right? So then there is a kind of malafidness involved in the claim. How do you say that the loss of profits you're justified because your equipment was, having technical problems, and then you cannot expect them to continue with the contract with you? And how did you tell them what is the profit you see from per machine?
The lost profits here, in this case for the 5 units that were not shipped, actually each unit costs $100,000, but we are claiming $100,000 for all the 5 units that were cancelled. This is an anticipated loss of profits that we think that these are the lost profits because of this contract not being performed as it was deemed to be performed in the very first place. And therefore we are claiming.
If the bench holds that you are in a breach of contract, would you be entitled to either of the damages?
If it holds that the claimant is in breach of contract, then no, we will not be entitled to such damages.
Okay, all right, proceed.
Okay, thank you. Article 62 of this convention states that the seller can require the buyer to pay the price, and this implies that the claimant can ask the respondent to pay for the unit that was shipped and delivered to it. For this, and further, for the purpose of the interest at the rate of 6%, we shall refer to Article 7.2b of the general conditions in this contract, wherein Article 7.2b states that an interest rate of 6% shall be levied by the vendor. Shall be levied by the vendor unless otherwise provided. Therefore, the claimant can claim this interest rate from the respondent. Moving on to my second submission, the counsel would like to submit that the claimant is not liable for the damages in lieu of the delay caused to Atlantino Construction Company. This submission is divided into 3 limbs. First, that the respondent has failed to mitigate damages under Article 77 of CISG. Second, that there was no reasonable foreseeability by the claimant in the context of this delay. And third, that the claimant is not liable for such losses because of the respondent's intervening acts. It is submitted that the respondent has not mitigated the damages.
Counsel, what according to you could the respondent have done to mitigate further?
Yes, Madam Arbitrator, I'm just coming to that point. For mitigation, it has been laid in ICAC case number 97 of 2004 that in cases where the respondent has a sub-buyer, they should try to negotiate the time limit with the sub-buyer as a first instance of mitigation. However, in this case, the respondent has directly contacted North Nest rather than trying to adjust this deadline with Atlantino Construction Company, whereas this is a reasonable measure of mitigation in this case, and therefore they have not reasonably mitigated the damages in this case under Article 77 of the CISJ.
Sorry, I think I have not understood your argument. What do you understand by mitigation?
Mitigation means that the party suffering the loss should take actions to minimize such losses.
Correct. So what should it have done? It contacted a third party to get another supply. It immediately sold the defective machine to whatever person it could sell it to, recovered whatever price it could, then wrote you enough emails telling you, this is not working, please send your person. I don't think there was anything else. Tell me one practical step that the respondent could have taken to mitigate its loss further.
Madam Arbitrator, when we were told about the defect from the emails, we shipped the alternator unit within the two days by air. Further, all we expected from the respondent was that they could have asked their sub-buyer to adjust the deadline for a few days to install the new alternator and then install these pieces in the multi-residential building under construction by the sub-buyer. However, they failed to do so because a simple negotiation with the sub-buyer could have avoided them to take such actions of cancelling this contract of 10th May 2015.
So according to you, mitigation should have been that they should have negotiated and sought extension for supply of the equipment.
Yes, okay. Precisely.
All right, proceed with this.
Further, I would like to move to the point of foreseeability under Article 74 of the CISD. Here, the Council would like to submit that there was no reasonable foreseeability as the contract that was signed by the parties on 10th May 2015 nowhere mentions that the respondent has further sub-buyer obligations in this case. The respondent has never mentioned that Atlantino Construction Company was the sub-buyer in the very contract that was signed between both the parties.
Contradictory to your previous argument. You just said that they should have taken mitigation steps by negotiating with the sub-buyer. And now you're saying that you didn't know about the sub-buyer. This is completely contradictory, isn't it?
Madam Arbitrator, we were not aware of the sub-buyer by the contract that was signed on 10th May. However, we came to know about such sub-buyer pursuant to the subsequent communication that took place with the respondent.
So did you tell them that your profits per machine is $20,000?
The profits per machine is not $20,000.
Yes, that's what it will be because you are now claiming $100,000 for the remaining 5 machines. So it comes to $20,000 per machine, isn't it?
Yes.
So did you tell them that?
Yes, Madam Arbitrator, that.
Did you inform them about that?
No, Madam Arbitrator, there was no. No, Madam Arbitrator, there was no such communication.
All right.
As these are the lost profits which are anticipated after the breach has happened.
Right.
Moving further, I would also like to state that the link of causation is disturbed by the intervening acts of the respondent itself. Here, I would like to, if I may have just one more minute to finish my submissions, Madam Arbitrator.
Yes.
Yes, thank you. I would like to bring the attention of the members of this tribunal on page 7 and 8 of the proposition. Here, by looking at claimant's exhibit 3 to 10, it will clearly show that there was a delayed response by the respondent to all the communication made by the claimant with regards to the defective alternator system. And secondly, the respondent has failed to install this alternator system sent by the claimant as soon as the claimant was aware of such defects. Therefore, it is not the claimant's causal link is not linked with the claimant and the defect, but rather the intervening acts of the respondent has disturbed this causal chain, and therefore it is the respondent who shall be liable for such losses of the delay caused. Moving on to my last submission, we would like to submit that the claimant should be getting the cost of arbitration and the lawyer's fee in this case, as the claimant has taken all steps to negotiate in good faith with the respondent, and also under the American.
One minute. Under which provision of law would you seek cost? Because under the convention, you can't get the costs.
Yes, Madam Arbitrator, correct. Under Article 74 of the Convention, these costs can be included. However, as the rules of the arbitration are the American Arbitration Association's rules, Rule 28.3 allows that the arbitrator shall not decide the case as an amiable compositor in this case. Therefore, the tribunal is not expected to uphold equity. And further, Rule 28.5 of this convention, of the rules of the arbitration, also states that the parties have not explicitly waived their right to be awarded the arbitration costs. So therefore, if the tribunal deems it fit, they can award the arbitration costs to the claimant.
Okay.
If Madam Arbitrator will just allow me to read my prayers.
No, the prayer can be taken as read. There's no need.
If Honorable President permits, I have a question to ask to the Council.
Yes, please.
Yeah. Madam Counsel, so far you have argued based on the facts of this case, but allow me to put a question based on the procedure of the case now. You have argued, you have come before an arbitral tribunal. Is there a valid arbitration agreement between you and the parties?
Yes, yes, sir, arbitrator, there is a valid arbitration agreement by the very perusal of the claimant's Exhibit 1, which states the contract of the...
Madam Counsel, you read your arbitration agreement. One of the important elements for any arbitration agreement is that parties should intend to be bound by the arbitration agreement. Now, if I read your arbitration agreement, two sets of rules has been provided here. One by the claimant side, one by the respondent side. So which means that you do not intend to be bound by the arbitration agreement.
It states that if the party invoking the arbitration agreement, if the party is Monsentanian, then the American Association rules shall apply. And if the party is an Atlantanian party invoking the arbitration, then the Greek Federal Chambers rules should apply. And since the claimant is an Atlantanio party, therefore the American arbitration rules will be applying to this case.
This is what you have drafted here. Say, tomorrow the respondent brings up a claim another. Won't there be a duplicity of proceedings before two different tribunals? So I don't see there is valid arbitration agreement.
The colleague judge is asking...
Sir, arbitrator, I just request you to...
Yes. The colleague judge is asking, the member of the tribunal is asking that since there are two separate rules which are governing the contract, since one body has not been identified as the agreed forum for adjudication of disputes, and there are multiple fora which are there for adjudication of disputes, there is no consensus ad idem on this, and there is a possibility of contradictory claims as well, because tomorrow, even if your claim is decided today by this tribunal, the respondent can raise a further claim with the Greek Federal Economic Chamber. And therefore, there is no consensus on the arbitration clause. And hence, the arbitration clause is not binding on the parties. That's what is being put to you.
Okay. All right, I get this. I would like to address this by stating that the parties have agreed that by the party, whichever party will invoke the arbitration, the rules of that particular party shall apply, and therefore, I think it is very clear that the other party shall also be bound by this arbitration, as it is clearly stated that if the party invoking arbitration is Monsentanian, the AAA rules will apply. And I don't think the other party shall be differing from this, as it is explicitly mentioned in the arbitration clause of this agreement.
Okay. Do you have any case where you have two arbitration fora provided in an arbitration clause under the International Convention of Sale of Goods? CISG?
No, Madam Arbitrator, I would like to apologize for this.
All right.
Thank you. It was a pleasure arguing before this tribunal.
Honorable member, if I may continue with the respondent side argument, much obliged. Very good afternoon to honorable members of the tribunal and Madam President. This is counsel number 1 representing respondent Peterson Backup Power Generator Company. And this counsel is going to deal with the issue regarding avoidance of contract, the justification of avoidance of contract. And my co-counsel will be dealing with the issue regarding the issue of self-help sale and subsequent reimbursement regarding it. Now, Madam Arbitrator, what we have done in the present case is that we have avoided the contract with Supreme due to fundamental breach on their part. Now, Madam Arbitrator, before coming on to as to how the facts of the case leads to a fundamental breach, I want to object to certain submissions that have been put up by the claimant. In the present case, Madam Arbitrator, the claimant has contended that the notice that we have sent pointing out to the non-conformity is unreasonable. No clear specification is mentioned there. The time that we have taken is also unreasonable. Madam Arbitrator, in the present case, by their very act of replying to that notice, they are accepting that there is fault in the goods. Secondly, they have also agreed that they would repair it. So in the present case, they have completely waived off their right to object to the said notice. Now, Madam Arbitrator, coming to the next. Madam Arbitrator, are you with me?
Yes, please.
Now, Madam Arbitrator, the claimant have pointed out that whether to repair the defect or not, they have the option to say. Madam Arbitrator, I want to bring your attention to the standard form of contract by which we are bound. Madam Arbitrator, I may share the screen for it.
Yes.
Madam Arbitrator, this is the standard form of contract, the general conditions of sale. Madam Arbitrator, if you look at clause 9.6 of the said...
General conditions for sale of under which convention?
Madam Arbitrator, this is a general condition of standard form of contract made by UNECE.
How is this binding? How is this binding on the case in the present case?
Madam Arbitrator, by virtue of the contract that we have entered into between parties, you may refer to clause 4 of the contract in Exhibit 1.
Let's see that.
Clause 4 of the contract.
Yes,
Madam
I've seen that. I've seen that.
General condition will be applicable. So, Madam Arbitrator, if you refer to clause 9, it contains the guarantee clause. This is the guarantee clause. It says that where the purchaser wishes to avail himself of the guarantee, he shall notify the vendor in writing without any delay of any defect that has appeared. On receipt of notification, the vendor shall, if any defect is one that is discovered by this clause at his option, repair the defects of goods in situ, have the defective goods or part returned to him, replace the defective goods or replace the defective parts in order to enable the purchaser to carry out necessary repairs. Now, Madam Arbitrator, what the claimant is pointing out that this phrase at his option should be interpreted concerning only them, that it is solely the option of the claimant to decide whether to do any four of the things here or not. Madam Arbitrator, this contract has to be read in accordance with the governing law. The governing law here is the United Nations Convention on Sale of Goods. Madam Arbitrator, now you may refer to Article 46, subclause 3 of the said convention. Madam Arbitrator, I'm sharing my screen for your reference. Madam Arbitrator, are you able to see subclause 3?
We are all able to see it, yes.
It states that if goods do not conform with the contract, the buyer may require the seller to remedy the conformity by repair unless this is unreasonable having regard to all circumstances. Now, Madam Arbitrator, what this unreasonable having regard to all circumstances mean? Now, Madam Arbitrator, I want to refer to a commentary on CISG by the CISG, a new textbook for students and practitioners by Peter Havers and Alastair Mullis by European Law Publisher. So this states that this book is primarily based on the commentary Schweinsteiger. He's a celebrated commercial international law scholar. So this book is based on, the organizer, would you please let me to share my screen? Yes. This commentary defines that the buyer can claim repair unless this is unreasonable having regard to all circumstances. Whether reasonableness is a defense available has to be decided by taking into account all the circumstances of the case by weighing buyer's interest in getting the repair against seller expense. So both interests has to be taken into account. Now, Madam Arbitrator, this commentary also mentions that what is more.
Speaker, 1 minute. Go
Yes,
back to the previous page. Just see this last paragraph. This commentary is going against you, actually.
Madam, which paragraph?
Just see the last paragraph. The fact that
cost of repair are considerably higher than cost of substitute delivery or advantage which the buyer will derive from the repair is a strong indication of unreasonableness.
Therefore, 1 minute. Therefore, this sentence says, if the cost of repair is higher than the cost of substitute delivery, if you still insist on repair, then that's a complete stand of unreasonableness.
Now, so, Madam Arbitrator, the facts of the case has to be considered in the present case. What position we are in? We have already.
Commentary is going against you, Counsel.
Madam Arbitrator, I need to refer to the next paragraph, very next paragraph. The commentary has to be read as a whole. Now, Madam Arbitrator, it says that what is more, one should also take into account which side is in a better position to perform or to organize the repair of goods. If the defect can be easily removed by the buyer or the contractor, easily available to them, and if the distant seller would have considerable difficulty in organizing repair at the place where the goods are, it may prove unreasonable. So, Madam Arbitrator, in the present case, you may refer to our communication to them. Madam Arbitrator, you may come to Exhibit 7. Exhibit 7, we have communicated to them that automatic alternator system does not function. We do not have available personnel to diagnose further. We have said that the automatic alternator system is not working, but we are not sure as to there may be no further difficulty regarding it. That's why we have said to them that you should bring your personnel in our country to repair the generator. Now, Madam Arbitrator, you may refer to the very next exhibit. It says that sending replacement alternator by air for you to install at our cost. Return the defective control unit for us to repair. Now, Madam Arbitrator, what the claimant wants in the present case is that to return the defective goods for to them for repair, and they are sending a replacement alternate generator. So now what they want us to do that, firstly, we have to install that replacement alternator. Secondly, they would repair the original alternator and again send to us, and again we have to install them and again return them the temporary alternator. We had said, we have requested them, since we have a timely obligation to perform. So we requested them for a one-time solution. They have completely negated that, and by sending the replacement part, by sending the replacement part unilaterally, we had no consensus on that. Unilaterally, they have completely abandoned us by sending it. Now, Madam Arbitrator, I want to establish as to how fundamental breach in the present case has taken into effect. Now, Madam Arbitrator, if you may look at the nature of the contract.
I just want one small question. Just one small question.
Yes, Mr. Arbitrator.
Yeah. See, now it is for the claimant to decide as to how actually they would replace the defective product by repairing or by replacing it anew. So now in this case, the claimants have very clearly said that they are going to give you an entirely new product. Instead of a defective product, they are giving on their own cost, and they are only asking you to pay the same price. So they're not asking you to pay the extra price, and they are only asking you to, send back the existing, one which has been defective. So in other words, according to the convention, so in case if the one of the sides take the measure to replace the product amicably, properly, in order to, whether it is defective or they send their personnel or repair it, or they are actually replacing it with the entire product. I think that is the highest form of, taking care of the defective product. So in that case, and they of course have every reason and every reasonable requirement that, you send back the defective product, we will get it repaired and do something with it. Don't you think that you have actually, gone overboard by responding, to this particular query without accepting their offer, which is a reasonable one, as per the convention, which is a reasonable one, according to the clauses of the convention. I think that's a very reasonable one.
I understand your concern. I would like to clarify. I have already earlier shown that what communication we have given to them, that the alternator is defective. But we don't know, since we do not have any competent personnel to repair. Madam Arbitrator, may I see for an extension of 2 minutes just to emphasize on the point of fundamental breach?
Yes.
Much obliged, Mr. Arbitrator. Now answering your question, Mr. Arbitrator, we have told them, since we do not have any required personnel to diagnose further, that's why they need to send their personnel to diagnose and subsequent repair. What reply that they have given is that, I have already pointed out that, please send us the defective generator for repair. So now what they want us to do is that we install that temporary alternator for some time. They would repair the original alternator, send to us. We again install it, again return the temporary alternator.
I don't think the seller is expecting you to install a substitute and again send it back and then send it back again. I think that's a little bit of a stretch of an argument, because even from the exhibits, it doesn't seem like that.
Madam,
totally replacing it actually.
They are actually replacing it completely.
Madam Arbitrator, what we understand from the communication that return the defective unit for us to repair.
That's because they want to repair it for themselves. They are not expecting to send it back to you.
Madam Arbitrator, we had understood that they were expecting us to again and again change the alternator and install the old alternator.
That's a very creative argument. Mr. Khanna, you're muted.
Yeah, you see, they have never said that they want to send you back the repaired part. Once they have sent you a new part, replacement part, they have never said that they want to send it back after repairing. That was never their case.
Indeed,
Mr.
Mr.
Imagination.
I also want to clarify one point. Here in the present case, the respondent, by virtue of long-standing business relation between them, we have concluded 22 contracts with them over a span of 10 years. They know as to what kind of business we are involved in, as to what are the timely obligations we had to perform in that business. Still, they acted without any cooperation, without understanding what the difficulty we have. And also in the present case, both the countries are different. Had we hired our repair personnel from the country we are, it would have taken much time.
I get the feeling that this entire thing that you put up of the generator not working was an absolute bogey, because on 9th November 2015 itself, you first got in touch with another supplier who was supplying it cheaper to you. And thereafter, you wrote the first email to the seller by saying that and you made it sure that you did not even try the alternate part that they put up for you, which they sent you. So you already had a cheaper supply, and that's why you...
Madam Arbitrator, the point that is being referred is a mere rumor. Had they cogent knowledge, I want to refer, that is a mere rumor. Madam Arbitrator, 1 minute.
Are you willing to make a statement that you did not enter into you did not contact Northwest Manufacturers Inc.? And are you willing to suffer perjury for that if we find you?
That is a mere rumor. Had they, Madam Arbitrator, let me substantiate. Had they had cogent information, they would have immediately resorted to an injunction remedy. Had they cogent information. In the present case, that is a mere market rumor. Now, Madam Arbitrator, coming to the main point here, whether there is a fundamental breach or not. In order to understand what is a fundamental breach, I want to refer to a judgment of House of Lords. Madam Arbitrator, for that purpose, I want to share my screen.
Mm. You're going
Madam
beyond your
Arbitrator.
time, so your colleague will have to cut down his.
Madam Arbitrator, only 1 minute. So in the very celebrated judgment of Swiss Atlantic Society given by Lord Upjohn, the citation is 1967, 1 appeal cases 361. It's the judge points out that what is a fundamental breach? A fundamental breach is one that goes to the very root of the contract. And how it has to be determined? It has to be determined concerning whether such breach or breaches do constitute a fundamental breach depends on the construction of the contract and on the facts and circumstances of the case. This judgment has been referred by a single judge of Bombay High Court in the case of Maharashtra State Electricity Board. This is the very judgment, Bombay High Court judgment. And that very single judge bench judgment has been upheld by Supreme Court in the case of Maharashtra State Electricity Board versus Datar Switchgear. Now, Mr. Arbitrator, coming to fundamental breach in the present case. In the present case, we had a very long-standing business relationship between two of the parties. We had concluded 22 contracts in the present case. They know as to nature of our business. Madam Arbitrator, 30 seconds only. Madam, they know as to nature of our business. They have also agreed to the fact that there was non-conformity. They know they were made aware of the nature of difficulty we had, that we had no skillful personnel to repair. Still, they have not repair, and it clearly constitutes a fundamental breach.
Okay.
That
Next
concludes my argument, and it was a pleasure to argue before Honorable Tribunal. Much obliged.
Your time will be cut down. Instead of 14 minutes, you'll only have 12 minutes now. Courtmaster, please take note.
Yes, ma'am.
Pleasant greetings on members of Honorable Tribunal. Am I audible?
Yes.
Much obliged. This is counsel number 2 representing the interest of the respondent in the instant matter. Honorable members, I'll be addressing 2 issues of the present memoranda in the instant matter. First is as to whether respondents act post avoidance of contract were justified. Respondent means ours act post avoidance of contract was justified. And second is with respect to the reimbursement that we did from the sale of the proceeds and the damages that we claimed. Honorable members, I would like to point out a particular fact. The contract was avoided on 2nd of December 2015. After avoidance of the said contract, the respondents undertook 2 acts. Firstly, we performed our obligations of preserving the backup power generator unit that was sold to us on behalf of the seller. The second act that we did was that we sold the said unit after preserving the same unit for a period of more than 7 months and reimbursed ourselves from the expenses of preserving the said goods. Mr. Arbitrator, honorable members, the council will now be justifying the said acts that were done by the respondent. To justify the said acts under CISG, I'll be making a 3-fold submission. Firstly, stating that our acts were justified under Article 86, which mandates us to preserve the said unit after avoidance of contract. Our acts were justified. Second limb will be that our act is justified. Our act of sale of the said backup power generator unit that we were preserving is justified under Article 88, Clause 1 of CISG. And finally, that our act of reimbursement is justified under Article 88, Clause 3 of CISG. Madam Arbitrators, coming to my first limb of the argument, if you may refer to Article 86 of CISG, Article 86, Clause 1. I have shared my screen, Madam Arbitrator and honorable members. Is it visible?
Yes, I also have it otherwise. Yes.
Much obliged. If you may take a look at Article 86, Clause 1, it provides, it deals with the buyer's duty to preserve the goods, and it provides that if the buyer has received the goods and intends to exercise any right under the contract or this convention to reject the said goods, he must take reasonable steps under the circumstances to preserve the said goods. Now, Mr. Honorable members, it is pertinent to note that obligation of taking reasonable steps under Article 86 only talks about reasonable steps under the circumstances. It does not talk about all possible steps to preserve the said goods. It only talks about reasonable steps under the circumstances. Now, the reasonability of the said steps depends on the circumstances and should be decided in accordance with what a reasonable person of the same kind in the possession of the buyer would have done. Additionally, the article also provides that the steps should be taken to preserve the goods only to the extent where it is not causing undue inconvenience or unreasonable expense to the buyer. Now, I would like to point out Claimant's Exhibit 12 to honorable members. If you may refer to Claimant's Exhibit 12, I will also
I just
share my
want to
screen.
ask you one small question. Can you sell it without notifying the seller?
Indeed not. We have notified the seller in the instant matter. I'll be coming to that also. We have sent a reasonable notice notifying to them that we will be selling the sale unit.
You did it, I think, before giving a notice. I think you have already started the process to sell it actually.
Mr. Arbitrator, we did not start the process before selling the unit. I'm coming to that if I may substantiate my argument.
Yeah, please go ahead. Yeah.
Much obliged. Mr. Arbitrator, if you may refer to Claimant's Exhibit 12. I've provided to you on the screen. Is it visible, Mr. Arbitrator and honorable members?
Yes.
Much obliged. Honorable members, the respondent, after exercising his rights on 2nd December, it is to be noted 2nd December 2015, we duly informed the other party, the seller in the instant matter, that the respondent, we are holding the goods at claimant's expense. We told them we are holding the preserving the goods on your expense. Further, in Claimant's Exhibit 14, if you may refer to 14, we again contacted to them and notified them after a month had passed on January 2016 that to remove their unit. We informed them, please remove your unit after preserving the same for the last 1 month. We informed that it is causing an unreasonable expense to us.
One minute, your notice, you are saying that you are giving notice, and at the same time you are saying you are cancelling the contract. You are asking them to replace it, and you are cancelling the contract. That means you are predetermined that you have to cancel the contract.
The council understands your concern.
Go back to that communication which you have shown.
Your
communication says, yes, Exhibit 12.
All right.
Your communication says that the seller is required to must supply the buyer working unit, cancelling the contract dated so and so. That means before they could remedify, you have cancelled it also. So that shows your predetermined mind that you wanted to just cancel the contract for a reason X, Y, or Z. And as Justice Pratibha Singh has rightly said, that you had a cheaper version available. Therefore, you wanted to get out of this contract.
The council understands your concern, Mr. Arbitrator. Would like to clarify. The claimants in the instant matter have argued that we were predetermined to not enter into the contract.
No, I'm just reading your communication. I'm just reading your communication where you are asking that must supply the buyer working unit. And at the same time, you are cancelling before they could remedify anything. That shows your predetermined mind.
Mr. Arbitrator, we are just providing in this notice the reason for avoidance of contract. We have already communicated the above in above exhibits. You can clearly see that we have already communicated them that what was the need of ours in order to repair the said alternator. We gave them time to repair, but they did not perform their obligations. Hence, they have already have committed fundamental breach under Article 25 of CISG also, which deals with fundamental breach. They have already committed the said breach. Now we are just avoiding and giving the reason. We are just giving the reason for the said avoidance. And furthermore, we are also notifying them that we are performing our obligation under Article 86, which says that we have to preserve the said goods after avoidance. We are just informing this to them. If you are satisfied, Mr. Arbitrator, can I move forward?
Yes, proceed.
Please proceed.
Much obliged. Mr. Arbitrator, additionally, I would like to point out that it was merely a rumor that we were going to enter into a contract with a third party, or we were in contact with third party. It is merely a rumor. It is provided in the Moot proposition also that it was clearly a rumor. Now, Mr. Arbitrator, if you may come to Claimant's Exhibit 17, come to Claimant's Exhibit 17, the respondent in the instant matter sold the goods.
Conduct is speaking otherwise.
Mr. Arbitrator, I will show you our conduct.
Your conduct is speaking otherwise.
I will show you my goodwill. I will show you our goodwill. If you may come to Exhibit 17 also.
Yes.
Now, we sold the said goods on 2nd July. If you may see, this claimant's exhibit clearly shows that we sold it on 2nd July. Before this, we sent them multiple notifications telling them to remove the said goods. There was a period of 8 months for which we preserved the said goods. Despite this period of 8 months for preserving, they did not take the said good bags. Hence, we have reasonably performed our obligation under Article 86, Clause 1. Coming to the second limb of my argument, that respondent's action of sale of the backup power generator was justified. If you may come to Article 88, Clause 1. Article 88, Clause 1 of CIC. Are you there, honorable members?
Yes, sir.
It provides for when the party is entitled to sell the goods being preserved. Article 88 allows the party who is bound to preserve the goods to sell them if the other party fails to take possession of the goods in reasonable time. Now, according to the articles, there are only 2 requirements that the respondent must comply with in order to exercise the option of sale. The first requirement is that there must be unreasonable delay by the other party in taking the property. And secondly, the reasonable notice of intention to sell the goods has been given to the other party. In the instant matter, as I've already highlighted by Claimant's Exhibit 17, that the respondent did not take back the said goods even after 8 months of preserving the said goods by the respondent in the instant matter. We notified them also multiple times that please take your goods back. Even then, for 8 months, they did not take it back. That provides the unreasonable delay. Further, coming to the argument that we have sent them a reasonable notice, if you may refer to Claimant's Exhibit number 16, we have clearly notified under this on 28th June. And furthermore, the previous notification also, Claimant's Exhibit 15. In this also, we have notified them that we are going to sell the said unit. We have informed them 2 times before the actual sale of the said unit that we are going to sell the units. Hence, we have provided them a reasonable notice also that we have an intention to sell, satisfying the mandate under Article 88, Clause 1.
How do you justify sending them only $40,000 out of $60,000?
Ms. Arbitrator, that is the third limb of the argument. The respondent's action of reimbursement of expenses for preserving the unit was justified under Article 88, Clause 3. If I may submit.
Yes.
Much obliged. If you may come to Article 88, Clause 3 of CIC. Now, are you there yet? Madam Arbitrator, are you there?
Yes, yes.
Much obliged. Article 88, Clause 3 of the CIC is concerned with costs that the preservation may have caused and provides that the party selling the goods has the right to retain out of the proceeds of sale an amount equal to the reasonable expense incurred for preserving the goods and of selling them. In the instant matter, the respondent has complied with all of the prerequisites for the sale under 88 Clause 1. Hence, in the instant matter, the expenses that we bared over the 8 months for hiring a warehouse and preserving the said goods for the 8 months, we can deduct an expense from the sale of the proceeds and hence can reimburse ourselves.
But the notice for preservation, sorry.
Sorry, Mr. Khanna, please go on.
No, your ladyship may ask, then I'll put it later.
What is the computation of the damages you've done from your side? Because there's nothing in the problem. I don't see it in your memorial also.
Honorable members, we have satisfied them a notice clarifying the said calculation also. If you may look at Claimant's Exhibit 17, we have clarified to them that backup power generator unit was sold for 60,000. Proceeds gave us back 60,000.
I'm sorry, there's some confusion. That is your costs for preserving the generator.
Indeed.
I'm asking liabilities to third parties. Come to page 19 of your memorial.
Indeed, that is the third issue. If I may deal with it.
Yes, deal with it.
I will substantiate the argument in that. Much obliged.
There is no computation. You need to compute. What is your computation of damages?
Ms. Arbitrator, in the instant matter, the damages that that we got from the third parties, they in the instant matter, the fact sheet firstly did not clarify as to what was the amount of damages that we incurred. Secondly, under Article 74 of CIC, it only mandates the respondent to provide a reasonable amount of the said damages.
How much are you claiming from us? You don't know.
Ms. Arbitrator, in the instant matter, the fact sheet does not provide the amount that we are claiming from them. In the instant matter, Article 74 mandates that the said loss or damages should only be foreseeable in the instant matter.
So now, we cannot award you X amount without computing it. You have to compute it.
Miss Arbitrator, that is what I'm suggesting here, that if you may look at Claimant's Exhibit 17. Claimant's
You're
Exhibit
happy with
17.
$20,000 then?
No, we are asking for $19,100. That encompasses the complete damages that we incurred, the preservation cost, everything. Only $19,100 is all we are asking for. There is nothing more. That is the amount. If you are satisfied, I will move forward. How satisfying how damages can be claimed.
Mr. Khanna had a question.
Indeed, Mr.
You see, your notice is of 20th of June 16, and in July you have sold. So how the seller will know that for the earlier period that you were going to sell it?
Mr. Arbitrator,
you have earlier said that you will preserve it.
Mr. Arbitrator,
then you give notice in June, and in July immediately you sell it after 10-15 days.
The council understands your concern, Mr. Arbitrator. Would like to substantiate. If you may look,
so the damages you will be entitled for retaining will be after the period of notice until you sell it.
Mr. Arbitrator, the cost of expenses for preserving is not damages. Those are not damages. Damages are the amount losses that we incurred from dealing with third parties, which we have also claimed. Now the expenses. If I may take an extra minute of 2 times to substantiate and answer the queries of the honorable members.
Council, with the permission of the honorable chair, I have one more query for you.
Indeed.
Since you are also making a claim here, and you are not merely appearing as a respondent in this case.
Indeed.
So the claimants had earlier argued that this arbitration panel is American Arbitration Center.
Indeed.
If it is an American Arbitration Center, you are merely a respondent here, and you are not entitled to raise any new claims here. Now, since you are raising a new claim, going by the arbitration agreement, the appropriate forum should be your International Arbitration Center of the Greek Federal Economic Chamber. So how do you pick up a new claim before this American Arbitration Center? You need to clarify whether we are American Arbitration Center or we are Greek Federal Economic Chamber.
The council very much understands your concern, Mr. Arbitrator. Would like to substantiate. Firstly, if you may refer to clarification, Mr. Arbitrator, the clarification of the Moot proposition in the instant matter clearly provides that the place for arbitration will be Athens only, and will be following the American arbitration rules. There are no 2 places. There is a clarification provided for the same of the said competition. If you may refer to clarification, I can clearly satisfy your arguments. Clarification, page number 2, question number 3, legal and jurisdictional, in which the question was asked, and the answer was that the place of arbitration shall be Athens. So there is only one place of arbitration in the instant matter, and that will be following the American arbitration rules.
I understand that. See, there is a distinction between the place and your seat of arbitration.
Indeed.
In this case, the place of arbitration is Greece, which I agree. The clarification also is accordingly. But what about the seat of arbitration? The seat of
arbitration in the instant matter is American Arbitration Association.
American arbitration, then how do you raise a new claim here then?
Mr. Arbitrator, for the convenience of the court, we have done this, because if we had instituted a separate suit, a separate arbitration in the other country, under the other seat of jurisdiction, there will be multiple arbitrations pending in the instant matter. For the sake of convenience of dealing with the remedies in one arbitration suit, and both in the instant matter, we have approached this question.
Does the American Arbitration Association rules permit you to file a counterclaim?
Indeed, Ms. Arbitrator. In the instant matter, res judicata will apply, and hence we can.
I'm asking you a different question. Does the AAA rules permit you to file a counterclaim?
Ms. Arbitrator, AAA rules does permit us to apply for a counterclaim in the instant matter.
Which rule is that?
Ms. Arbitrator, can you give me 1 minute? I will point it out to you.
Okay, so I think your time is up now. You can conclude.
Ms. Arbitrator, can I substantiate the damages clause? Summarize in 1 minute. I will summarize it in 1 minute.
Yes, because I'll have to cut marks otherwise, because you're taking too much more.
Only 1 minute, Ms. Arbitrator, if you may permit.
Yes.
Just to summarize. Much obliged. Ms. Arbitrator, damages for liabilities to third parties and cost of arbitration is claimed under Article 74. Ms. Arbitrator, Article 74 provides for consequential damages. to claim consequential damages. If we were to take a look at Article 74 also, it provides for consequential damages. Liabilities to third parties comes under consequential damages. Since these are the economic losses incurred with dealing with third parties, which we can claim the level. Coming to the cost of arbitration, if I may substantiate cost of arbitration as damages.
You can take it as read. I've read your memorial.
Much obliged. If I may come to the prayer, if the honorable members are satisfied.
No need. We've read the prayer. Please come.
Much obliged. Please come to Ms. Arbiter. Can you please pardon?
Will now come for their rebuttal. Yes.
Okay. It was a pleasure pleading before this honorable before the honorable members.
Yes.
Members of the tribunal, the counsel of the claimant would like to incapacitate the arguments put forward by the respondent one by one. First of all, it is stated that it has been found in, according to Cloud case number 97, that a seller's offer to remedy the goods did not constitute an admission that the goods lacked conformity. Second, it is submitted that the respondent have argued that this is just a rumor that they entered into a third contract. However, there is no smoke without fire, members of the arbitral tribunal. If they did not enter into a contract, then why did they not give the claimant additional time to fulfill the contract? Their claim has been that the time of the delivery in the contract is of importance, and that is why they could not give us extra time. So that argument is not substantiated. Second, if they are claiming that they have indeed followed the American Arbitration Association rules, then why have they not come before the International Center for Dispute Resolution? They have just written in their memorial, Arbitral Tribunal of Athens. Which arbitral tribunal of Athens? Different arbitral tribunals have different jurisdictions with regards to different matters. This does not specify the jurisdiction of the tribunal in the first place. Moreover, they have also claimed contested the claimant's authority to choose the remedy. In this context, the council would like to mention that by virtue of Article 6 of the CISG, both the parties have agreed in the contract to vary for the general conditions and hold that for the general conditions, it is the law of general conditions of sale for the import and export of durable goods which will be held, according to which it is the claimant who has the right to choose the remedy, and there could have been no immediate remedy than sending of a substitute goods by air. Just one last point for 15 seconds. Even if we hold that it is the CISG Article 46 that has to be applied, then according to 46.3, unreasonable costs there should be a reasonable ratio between the costs involved and the price of remedy. In this case, sending personnel from one country to another foreign country, first to diagnose, then to rectify, does not amount as reasonable costs in the contract, and therefore is unreasonable and not expected of the council in this case. Just one last line, that we have completed all our obligations as per the contract. We have delivered the good on time. We have sent the remedy immediately. We have also asked them to pay for the good. However, the intention was to avoid, and that has been done by the respondent. Thank you.
Researcher, please.
Ma'am, this is the counsel for the respondent. Now, should I go for the rebuttals?
No, let the researcher also finish and then we can come to you.
Sure.
It is submitted before the respective tribunal that errors in respondent's memorial are as follows. Firstly, respondent in their cover page has incorrectly identified the arbitral tribunal as pointed by the co-counsel. Secondly, on page 8, it is ambiguous on which commercial contract principle is respondent relying to substantiate its argument. Thirdly, on page 11, respondent had made a factual error as it states that the fact that the unit was not working was known to respondent within 12 days of delivery, but the same was revealed after 19 days of delivery. Lastly, on page 9, respondent states that if one party cannot perform its obligation in relation to one installment of the contract, then the other party can avoid that particular installment of the contract only if non-performance amounts to fundamental breach. But on page 13, respondent states that if the breach has occurred in respect to one installment, which might not be necessarily fundamental, then respondent can conclude a breach would occur in all installments and avoid the contract in its entirety. The respondent here is contradicting themselves. These are the submissions by the claimant for the errors made by respondent.
Thank you.
Thank you.
Madam Arbitrator, may I continue with the rebuttals?
Yes, and you will stick to your time.
Yes, Madam Arbitrator. I have 2 points to state. Firstly, that they have said that we have avoided the whole contract even if there was defect in the said goods. Now, in order to avoid the whole contract, the convention itself states that if there is a good grounds to believe that one fundamental breach would lead to subsequent fundamental breach, then in the present case, the whole contract can be avoided. In the present case, what is the good ground for us? The good ground in itself is that these generators are consumer durables. These are manufactured in batches. When there is a manufacturing defect in one generator, there are bound to be manufacturing defect in subsequent generators. And that is the very good grounds for us to avoid the whole contract. And Madam Arbitrator, one thing I must highlight you, Madam Arbitrator, I want to share the screen for this purpose. Madam Arbitrator, this is the sample photo of the backup power generator. And for us, a middleman, how would one expect to repair the said complex machine? They are bound to send the personnel. This is very complex as a layman looking at it, that is very complex. And it is not possible for a reasonable man to diagnose the said generator. That concludes my submission.
Okay. Researcher from your side?
Very good afternoon to the Madam President. This is researcher appearing on behalf of the respondent and will be taking 1 minute of this tribunal's precious time. I'll be substantiating merely on the merit of the issue. I will not be pointing out the typo in the written submission of the claimant. So there is a 3 submission to make, Madam President. Kindly please have a look on the page 22 or in the 3rd issue written by the claimant in their written submission. Peterson is liable to pay the damages for breach of contract and failure of the payment of the first shipment. In this 3rd issue, Madam President, the claimants have demanded damages amounting to $10,000 plus interest. However, the claimant have failed to substantiate 4 points. Firstly, as to how did they have arrived the calculation of 10,000 as the amount being claimed for a damage under Article 74. There has been no account of loss provided in the written submission. Secondly, Article 74 puts a limitation of damages, put the damage claim of forcibility of the said loss to be breaching party. The claimant has failed to substantiate as how these losses were forcible. Thirdly, as to how they have mitigated the loss under the mandate of Article 74, 77 of the CIG. And lastly, the interest on damage cannot be claimed under CIG. Now, Mr. President, Madam President, kindly come on the page 12 of the written submission of the claimant, which talks about the avoidance of contract by Peterson amount to fundamental breach of contract. Whereas there is no law that says that if the defective goods are sent by the seller, then the buyer cannot withhold the payment unless the goods are remedied by the seller. You may refer to the recycling machine case, Mr. President.
Okay, thank you. Court Masters, that ends the proceedings?
Yes, ma'am.
So can we ask the participants to exit so that the judges can have a discussion?
Ma'am, we can make a separate breakout room for all the members of the tribunal, and you may join there. You'll get the request.
No, then we'll have to redial. So why can't the participants exit from it?
Ma'am, you will not need to redial. You will just have to accept the request.
Sorry?
You will just have to accept the request that will pop up on your screen, ma'am.
Oh, I see. Okay, no problem.
So they do that.
Create the breakout room then, please.
Yes. Done, sir. Done. Okay, sir.
I must say it was a wonderful effort by both the teams. While the judges are out, I will just take some time to be with all of you. It was a wonderful effort, and actually today what we have seen is how the court proceedings really happen. This is how VC hearings happen, and I hope it was a learning experience to all the teams during this moot court. This is the future of what things are to come, and it was wonderful to see all of you give your best during this time. And once again, I will take this opportunity, though I'm not in the list of speakers today, that OC has done a wonderful job organizing this event. And best of luck while the results are being compiled. And may the best team win. But I think both the teams have done wonderfully well and both deserve to win, actually. Pinky ma'am, are you there?
Ma'am is probably with the breakout room.
I also got an invite. I thought I will stay away from the breakout room while they are deliberating and deciding what is to be done. Is it the team's first experience of VC Moot, or have you people done earlier also?
Sorry, it is our first experience.
So how did you find it?
It's good, but it's a bit of difficult while you are referring to authorities, as you have to share the screen in between. That I thought it was a bit of cumbersome thing. Rest,
of course it is.
Rest, it is very it's very easy. Otherwise, we had to travel a lot. We had to go there. We had to stay. We had to arrange for things. Now it's like we are sitting from home and we are participating. So it's it's very easy.
What is claimant's view?
So I feel that the true, enjoyment in a moot is going to the place, meeting the fellow mooters, having conversations beyond the courtroom. At this point of time, you're not able to interact with anyone. And also, I don't think the experience of actually standing on a podium and then arguing can be replaced through a virtual room. But still, it was fun. I won't say that it wasn't fun.
This was your first time as well on a VC Moot?
No, it was my second time. Oh, no, VC Moot, yeah, first time. Yeah.
Okay.
Yeah.
See, what has happened is that you kids are still technologically much advanced than us. We grew up with books and, we were just getting used to doing research on the laptops and things like that when this pandemic hit. And imagine how difficult it is for the councils to move. I'm so sorry, ma'am. I was just talking to the participants while the judges were in the breakout room. Ma'am, you're muted.
We'll meet at 1:10 again. I'll email the score sheet to the organizers.
Ma'am.
Okay.
Expected, ma'am.
And Khanna sir, how did you find the moot?
Excellent, Sachin. It's a very good initiative. There was some confusion. There was some confusion. You see, I thought I was to only join for valedictory because that is what I was told. I was not knowing that you see, I have to join at 11:30.
Sir, we had sent invitation for both final round as well as valedictory, sir.
No problem.
Judges of the final round, they are the part and parcel of the valedictory function.
Yes,
did you enjoy this, sir?
Madam will join at 1:10. Meanwhile, can I make a request to Mr. Sachin Puri to say a few words because today he has attended this final round, sir, please.
Ma'am, I have already done that. I was speaking to the teams. I just wanted to know from Mr. Khanna, did he enjoy this experience?
Yes, sir. That's true. But what is your opinion about the 4 days long competition, sir? We have 5 minutes.
In fact, sir, this went on for 4 days. We started it 4 days back, and I was sharing it with the students all along, and even yesterday and today. That imagine for the councils who have to adapt to VC hearings at this stage, not having much know-how about computers, and sometimes the systems crashing, bandwidth not being there. But for these students, it's just like future preparing if ever it was to happen to them once they join practice.
Yes, sir, that is true. Yeah.
Khanna sir, can't hear you, sir.
I'm saying it's a lovely experience. In fact, I wanted that you should tell the judge also, because you see, there is a lot of things which are going on. This virtual hearing, is a wonderful experience in itself. Morning, I was judging moot court on mediation held at Malaysia, and and I had to get up at 5:30 to judge that moot court. But the wonderful experience was that our children from different parts of the globe, they were participating, and it was, as if they are all sitting in a room and we are doing it. So that was in itself, it's a very good thing. And that, is bringing the distances, rather finishing the distances between the countries.
True, sir. And sir, I must also, at the cost of repetition, say that the OC has done a wonderful job, the students and the faculty, for bringing it together. And, they've been working till late, ensuring connections, ensuring everybody is there. In fact, sir, we had 3 international teams also for this Moot, and we had about 32 teams. Unfortunately, once we shifted to the VC platform, originally this was proposed for March this year. Then the lockdown started, and once we shifted, there were a lot of changes that took place during the course. And finally, the OC really had to take a call, change the rules, change the criteria, and then go ahead with the organizing of this Moot. And this, in fact, in the earlier rounds, it was Manmeet and Kanika, if I remember correctly, both of them had really worked hard to bring this together. And I'm really glad that the students have enjoyed their experience, though I'm sure they are now waiting for the final results to be. But it was really a keenly and nicely contested final.
No, but all credit goes to you, Sachin.
Yes, sir. Yes, sir. I agree with Mr.
Taking this initiative and bringing everybody on board and starting this, the credit goes to you.
Sir, in fact, sir, it has been our endeavor from the beginning to bring it closer to the courtroom experience. And today, the way the judges took it.
Only thing is, this moot court we have done. But what will happen to our cricket tournament? How will we organize that virtually?
True, sir. In fact, I don't think the students know I play for Sir Steve in the Supreme Court Bar Association cricket tournament, and he happens to have one of the best teams in the country.
All my friends, they have been asking what will happen to RKJ, I said, wait for some time. Let this pandemic be over. RKJ tournament will remain, but this pandemic we have to pass over.
And sir, in fact, I must also tell them this year, in the first match that we were playing, of course, I did not score a run. I did not even go into bat. But Sir's team, which I was a part of, proudly to say, scored 375 runs in 20 overs with 2 centurions.
What a really great team. A really great team.
It's join the practice probably if anybody ships to Delhi, and they can have lots of, these are the things which are so important when you get into practice, that you have different types of things. Sir, in fact, I was going to say something with ma'am's permission also. That
एक बार मैं बीच में रोकना चाहूंगी. इस बार मूट कोर्ट में एक फायदा तो हुआ, बहुत सारे राज बाहर आए कि we have with us cricketers. उसने जस्टिन सूदी के बारे में आपने बताया था, आज अपने बारे में तो बताया कि आप भी क्रिकेट खेलते हैं. सर, आपने उस दिन नहीं बताया. I would have mentioned then and there only. Thank you so much, Mr. Khanna. आपने अगर मैडम सर से बात की तो भी पता चला कि हाँ, we have cricketers with us in the present moot court competition.
In my college time, I used to play. Now, so we play a veteran cricket with Supreme Court judges.
And even, ma'am, I must say it is not easy to have a team, believe me, I know it. And then to keep all the kids together, and sir takes special effort, to invite everyone for dinners, coffee after a match, or, it is wonderful when you sit down with everybody and have that half an hour or 1 hour interaction. It is lovely. Those bonding is so important.
See, at the end of the day, Sachin, this is our family now. We, the lawyers, are our family. And within the family also, you feel that, you see, here is a group which is very close. And I tell you, we have won the Supreme Court tournament 3 times continuously. And every time the boys, they prepare the team themselves, they just say, sir, this is our team and we are playing.
Yes, sir. I know, sir. In fact, I must share that other than the Supreme Court tournament, I have a team which plays, and so most of sir's members are also playing with me during the other tournaments. So when I used to play.
Just give me 1 minute, huh?
Yes, sir. In fact, ma'am, what I was proposing in the years to come, when we proceed with the moot court, I wanted to introduce a round of cross-examination instead of a fact sheet as conventional moot courts have been having. So
yes,
those
sir, it's a great idea. Very good.
For that special rule I have in mind in the year to come, we will have that. And hopefully, if the faculty agrees, we should look at organizing it by March through VC only. While we have the benefit of VC, we should have another round of moot court, but with very different rules and different spectrum to cover. It will not have simple fact sheet, but we will add the plate and we will have the written statement, and then we will have the cross examination primarily done, and have about each team will get an option to have 10 questions to one of the witnesses put in, and those specific questions and answers will only be used by that team during their case arguments. And similarly, the teams, when they exchange their memos, that will be a sheet attached there too. Sir, I was saying that in order to bring it closer to the practice level, I've been thinking, subject to what the faculty agrees, to introduce a round of also cross-examination and now take it to closer to the trial stage in the next year.
Yes, you can do that also. And that I was telling you in the morning when I was doing that Asia level moot court on mediation. Because you see, in the latest field after arbitration now, the world is moving towards mediation, and that to pre-litigation mediation.
Yes.
And you see, this is something looking into the cost involved, looking into the time involved. You see, a new concept which is developing all over the world is regarding the mediation.
Yes.
And you are certainly right. You see, then you can have a competition, dedicated to cross-examination. You see, the art of cross-examination in itself is a very good and very, specific art. At times, you must have noticed one wrong question put up by a counsel finishes the whole case, and one wrong answer by the witness finishes the case.
So absolutely. So I'm always reminded of one example my father used to tell me when it came to cross-examinations, which he had studied during his time, was that there was a case where the accused had bit the ear of the victim, and the cross-examination was being done where the eyewitness was asked that, what did you see? He said, did you see him bite the ear? He says, no, I did not see him bite the ear of the victim. He said, then what did you see? He said, I saw him spit out the air out of his mouth. So one question changed the entire case. So I think, sir, we'll try to do that. So have some innovation.
Yeah.
Sir, last time you suggested that we should have paperless moot court competition, and
This time
somehow it happened. And now whatever idea you have given, I endorse it, and hopefully in the next one, which we will organize in March 2021, that will be implemented. Thank you so much, sir. We always get wonderful ideas from you. Thank you so much, sir.
Always welcome, ma'am.
Sir, other two judges, what is their opinion as far as the today's competition is concerned? Can we ask Professor Hegde and Dr. Abhijit?
We have to speak as well, I think, in next 10 minutes.
I know, but this was purely informal discussion.
Yeah, but I think it was pretty good in the sense, I think it trains students, in complex arbitration issues. But only problem, I think one problem is that they've given convention, but I think as Dr. Kumar Abhijit mentioned, it also seeks to look at implementation issues. See, for example, an arbitration is generally held under what law? So applicable law, and then of course arbitration rules, of course they are important. But I think those issues of course, questions were asked. But I think the problem is pretty, in that sense, it is pretty simple one, but brought out the major issues relating to sale of goods, convention and all those things. I think that was a good experience for students to study the convention, then also study the various other sources. But only thing I saw was most of them were arguing on the convention, but other cited materials have not been used. Uncitral materials, and then there are other materials also could have been used, except of course some of them made references to cloud. But apart from cloud, I think you could have used, some of the decisions, not decisions really, but how far these conventions are adopted. Actually, if you look at it, only 18 countries have signed the convention. So it is a framework convention, and it has to be applied within the United States or Greece, wherever it is, according to their own laws. We have a Sale of Goods Act. Similarly, they also have a Sale of Goods Act, which according to which they will have to implement. And this is a very complex issue in any given arbitration. That's on substantive side. But I think on the side of the argument, I think students have done pretty well in arguing it out on a complex issue. And also, it makes a lot of difference between arguing on I'm sure judges and senior advocates are all have adjusted to it now in the courtroom. But for students, it is always good to face, and then I'm sure, will do better in case if they, argue it out. I'm sure particularly they'll get a feeling that they are before court, and then I think will come out better in case if it is more. Of course, we can't do anything about it because of the circumstances right now. So it has to be virtual. But I think in the given circumstances, I think they have done the best. And then now maybe next 1 year or so, they'll have to get used to this kind of moot courts, happening. And one advantage is that when you make it international, I suppose now with the virtual courts, you can get teams from other countries easily in the next 1 year or so. So, and with more complex problems, I think. So that is one advantage, which has both advantages and disadvantages. That's all. I think the Justice Pratibha Singh is saying.
Yes,
I
I'll just
think
read the score sheet, Sachin, to you.
Thank you so much, ma'am. And I would request the host to start the proceedings.
Yes.
With ma'am's permission. Thank you, ma'am. Thank you, ma'am. Thank you. I'm so sorry. Please start.
No, it's okay, sir. It is only in our darkest hours that we may discover the true strength of the brilliant life within ourselves that can never, ever be dimmed. These words of Doi Zentamata sums up the efforts which is put in by our honorable judges, participants, faculty members, and the organizing committee of the SK Puri International Moot Court Competition, Justified 2020, in light of the COVID-19 pandemic, which has taken a heavy toll on all of us. A very good afternoon to one and all present here today. To conclude this glorious and successful event, we are privileged to have with us Honorable Justice Pratibha M. Singh of the Delhi High Court as our chief guest for today's event. We are also honored to have with us Senior Advocate Mr. Rakesh Khanna, Professor V.G. Hegde from Jawaharlal Nehru University, and Dr. Kumar Abhijit, Legal Officer in the Ministry of External Affairs, as our guests of honor. The competition is organized every year by Law Center 2 in remembrance of late Shri S.K. Puri, Sir, and we are also honored to have with us today his illustrious sons, Mr. Gaurav Puri and Mr. Sachin Puri. I would really like to request Mr. Gaurav Puri to kindly deliver the welcome address.
Good afternoon, everyone. On this occasion of Shri S.K. Puri Memorial International Moot JUSTIFIED 20, I welcome distinguished dignitaries, professors, and participants who have gathered together at this moment to join us in celebrating the completion of JUSTIFIED 20. On this day, it is my unique privilege to extend a very cordial welcome to all of you on behalf of the organizers, students, myself, and especially the students who have worked in the organizing committee to bring this spectacular event in working. We feel particularly honored and gratified that Justice Pratibha M. Singh is in our midst today in the final and closing ceremony of JUSTIFIED 20. I also welcome Mr. Rakesh Khanna, Senior Advocate. I also welcome Professor V.G. Hegde and Dr. Kumar Abhijit. Justice Pratibha M. Singh is a known personality and does not require introduction. But still, I will try to refresh our memories. Justice Pratibha M. Singh completed her 5-year law course from University Law College, Bangalore. She graduated as the first rank holder from Bangalore University and also represented India at the Philip C. Jessup Moot Court competition in Chicago. She was offered scholarship by Cambridge Commonwealth Trust to study LLM at the University of Cambridge. She enrolled with the bar in 1991. Before being elevated to the bench, she was a leading intellectual property lawyer in India. She had the distinction of handling landmark matters in all areas of IPR laws, including patent, trademark, designs, copyright, internet laws, etc. She was appointed as amicus curiae by the High Court of Delhi to streamline the working of Copyright Office. She was also appointed on a high-level committee for streamline of patent examinations. She was invited as an expert to present views on parliamentary committee consists amendments to the Patents Act, Copyright Amendment Act, etc. Ms. Singh was designated as a senior advocate by the Delhi High Court in December 2013. She was a member of IPR think tank, which was entrusted with the task of drafting India's first national IPR policy, which was released in May 2015. Her article, India, Look Behind the Headlines, India is a game changer in patents law, implementation of Commercial Courts Act, CRI guidelines, expedite trials in patent cases, etc. have been published in leading international and national publications. She has been a regular speaker at various national and international IP-related workshops, seminars, and events. She was also a member of CII National Steering Committee of IPRs. Various awards were given to her, including the IP Litigator of the Year 2012, the Asia Women in Business Laws Awards, given by Managing IP for Excellence in Litigation, IP Lawyer of the Year 2013 by Legal Era, Best IP Senior Counsel of the Year 2014, and the Woman Lawyer of the Year 2015. She was elevated as a permanent judge of the High Court of Delhi on 15th of May 2017. Justice Pratibha M. Singh Scholarship of LLM Students was instituted at University of Cambridge in 2013. So scholarships are granted to Indian students who have secured admission at Cambridge for pursuing their LLM. After being elevated, Justice Pratibha M. Singh has given various judgments, especially during this pandemic, on force majeure and its importance during the pandemic, and every breach of non-performance cannot be excused merely on the invocation of COVID-19 as a force majeure condition. We welcome you, ma'am. Next guest, Mr. Rakesh Khanna, Senior Advocate. Mr. Rakesh Khanna started his practice at Chandigarh in the year 1982. In 1990, he shifted to Delhi and has since been practicing in Supreme Court of India and High Court of Delhi in the areas of civil, constitutional, commercial, and corporate laws. In 2010, he was appointed as Additional Advocate General for the state of Punjab at the Supreme Court of India and continued till 2017. He has represented many government and private bodies in various litigations, including service matters, land acquisition, civil and commercial litigation, alternative dispute resolutions, arbitrations, competition law, business and commercial law, corporate laws, mergers, takeovers, etc. He has been practicing for the last 38 years and has established his practice in Supreme Court of India and High Court of Delhi and has been handling various arbitration matters. He has argued matters pertaining to constitutional law, civil and commercial litigation, writ jurisdiction and original appellate side of the High Court and the Supreme Court of India. We welcome you, sir. Our next guest is Professor V.G. Hegde. Mr. Hegde was part of the Indian negotiation team on several bilateral investment and trade agreements. Mr. Hegde was also worked on WTO issues, particularly on dispute settlement and trade-related aspects of intellectual property rights. Mr. Hegde was a member and working group of the Arbitration and E-Commerce constituted under the auspices of the United Nations Commission of International Trade Law. Mr. Hegde also worked on the negotiation positions concerning India bilateral and multilateral watercourse agreements. His doctoral work was on developing countries and the regime of intellectual property rights. He has worked on various aspects of intellectual property rights, such as Indian patent system and the Paris Convention on Industrial Property, IPR, and patenting of life forms. Formations, it is implications of the Indian patent system. Many of his writings have been published in various national and international journals. Dr. Hegde is also visiting faculty to the National Law School, Bangalore and Kolkata, Indian Law Institute and the Indian Society of International Law. He has also been invited by National Judicial Academy as the recourse person to deal with the issue of between international law and multiple law within the specific context of the Indian higher judiciary. We welcome you, sir. Dr. Kumar Abhijit. Mr. Abhijit completed his doctoral studies in the Institute of Air and Space Law from Germany. He holds a Master of Laws degree from National Law School of India University, Bachelor of Sciences and Bachelor of Laws degree from the University of Delhi. He has also more than 8 years of teaching experience in the NLSIU Bangalore. He has done his fellowship from Sweden as well as from Belgium. On the occasion of 50 years of the Outer Space Treaty, he was part of the 21-day workshop on space law conducted by the Center of Studies and Research of the Hague Academy of International Law, the Netherlands. Dr. Abhijit is an alumnus of the International Visitor Leadership Program, a US government premium professional exchange program for emerging international opinion leaders. He has published a number of papers in reputed journals and has been an inviting speaker in number of distinguished conferences, including the first United Nations Conference on Space Law held in Moscow, Russia. He is also a member of the International Institute of Space Law and International Law Association. Currently, Dr. Abhijit is working with the Ministry of External Affairs, Government of India. We welcome you, sir. The S.K. Puri Memorial International Moot Court Competition Justified 20 is being held through video conferencing due to the COVID-19 pandemic. And the competition has witnessed participation from various teams. The object of the competition is to provide law students from all over India and the world an appropriate platform to enhance their knowledge and skills towards their journey in becoming a lawyer. With regard to the present distinct, we have had 3 international registrations for the competition this time. This was the first large virtual event that Faculty of Law has organized. Total registrations were 32 and virtual participation was 24. So much so the team from the University of Jammu had to travel from Jammu to Udhampur district just to ensure that they are able to participate in the oral rounds. 60 plus judges and faculty members, more than 50 volunteers were involved in organization of the whole event. Justified 20 was originally to be held in March, but was shifted due to COVID lockdown. Our thanks to the organizing committee and the student and teachers. And a special thanks to Miss Manmeet and Miss Kaneka, who had been instrumental in doing all the hard work since March, which was eventually done through video conferencing. And also a special thanks to Mr. Praveen Sharma, advocate, who has given full support. Thanks, Praveen, for being there. With this, I also welcome all the participants who have participated in Justify 20, and I wish the participants a very best of luck. Thank you.
Thank you so much, sir, for such a warm welcome. Our first guest of honor is Dr. Kumar Abhijit, former assistant professor at the National Law School of India, Bangalore, and he is currently a legal officer in the Ministry of External Affairs. Sir is an alumnus of the prestigious International Visitor Leadership Program, the US Department of State's premier professional exchange program for current and emerging foreign leaders. Sir, it is a moment of pride and privilege for our college, for Law Center 2, to have you with us today. I would really like to request you to enlighten us with your words of wisdom.
Thank you very much for that warm introduction, and also thanks to the organizers for organizing such a prestigious moot court competition and giving us the chance to be part of it. My sincere thanks to Professor Pinky Sama for inviting me here and being in the company of illustrious judge, Madam Justice Pratibha Singh, then senior advocate, Mr. Khanna, Professor V.G. Hegde, Mr. Puri for organizing this event, the students and the participants. Also the convener Abhishek, I would like to thank him that he has been quite instrumental with regard to conducting this event and also inviting me. Rather, this 1 hour of the session with the students was quite nostalgic for me. I had been down the memory lane 15 years back when I was a student in this law faculty. And I also used to participate in the moot court competitions. At that time, I could realize what could be the difficulties when a judges put questions to you and you feel like, okay, I have not been given adequate chance to argue before them. Where the judges would feel, oh, I am not getting my answer, so why should I listen to this argument at all? So I can understand the temptation what the students were having here. But then I must agree, both the teams had really done very, very well. Since it is a competition, that too it is being a final round, so it becomes more a task for the judge to find who is the best. And in the final round, it's really very difficult because the margin is very, very less. So that way, my congratulations to both the teams. But few things I would like to point to the teams here is that now normally in a moot court, when a problem is given, you need not to be confined just merely to the facts, but also you can bring up some kind of creativity there. You also need to think out of the box that, okay, what kind of legal issues are there? Is it merely confined to the facts, or some kind of legal issues would also be there based on the laws? So if this is where, if you are able to make a distinction with regard to the laws, bring up some new arguments, this is how your argument becomes distinct from any other team, and which also enable the judges to take a decision there. As far as this moot court competition was, since it was concerned with the arbitration, so what I expected more was that the teams could have prepared with regard to the fundamentals, like with regard to the arbitration agreements, the differences between the seat and the venue, the role of the arbitrator, the applicability of laws and other things. Otherwise, I understand in a given time period when we all are struggling with COVID, the world has shrunk to one room. We are all virtually connected and trying to argue or bring up something new before the world there. That way, my appreciation to both the organizers as well as to the students for doing such a wonderful job here. I would not take much of the time here because I would like to listen more from the Honorable Chairperson today, as she was a great inspiration for me as well here. I thank all the organizers for this opportunity. Thank you very much.
Thank you so much, sir. Moving ahead, we have Dr. V.G. Hegde, Professor, Center for International Legal Studies at Jawaharlal Nehru University. Sir has also worked as a senior legal officer in Ministry of External Affairs, where he was a part of the Indian negotiating team on several bilateral investments and trade agreements. Sir, we are honored to have you with us today. I would request you to kindly illuminate the budding legal minds with your inspirational words.
Thank you very much. I hope all of you can hear me. First of all, let me thank the law faculty, particularly Professor Mahavir Singh, Professor Pinky Sharma, and also all the colleagues from the Puri fraternity for organizing this excellent arbitration-related, moot court. Also, it's very nice to be on the panel along with Justice Pratibha Singh, who has been quite inspirational in that sense that she has been working on intellectual property rights and has an occasion to meet her at several times and discuss on these issues because both of us have a bit of a common interest in the intellectual property rights apart from other things. So I wished and also was very happy to be, guided by her in this particular program, and also wish to associate with Mr. Rakesh Khanna, Senior Advocate of Supreme Court, and also his excellent questions which he had raised on the arbitration issues. I think as put by Mr. Rakesh Khanna earlier, I think arbitration and mediation is increasingly becoming very important in the current context, as I can say it. During my earlier days as legal officer and later as a senior officer in the Ministry of External Affairs before coming back to JNU, I think we negotiated a bit of a lot of work during the United Nations Commission on International Trade Law, where particularly on arbitration, I think I had the occasion to attend several meetings. There in particular, I think it was on arbitration, where, that time the internet was coming and then, the entire issue of implementation was a very important sort of a central focal point, that point of time. In particular, because when you look at New York Convention, it actually says agreement in writing is the question which actually had to be decided. So what is to be in writing? So this was the issue which was debated for a very long time within UNCITRAL. So what is not in writing is also writing. This is what exactly has been defined by the guidelines which were issued after a long negotiation within the United Nations Commission on International Trade Law. I think there are drafting, there is a whole guidelines, and then also the what is called as declaratory sort of a norms which were created for the New York Convention 1958 for the implementation of arbitration awards, where exactly they define what actually is writing. So there are a number of changes which have happened. Also, of course, UNCITRAL, we are actually talking about the convention today, the CSLG, which is the original byproduct of the UNCITRAL negotiation, which went on for a very long time. This was one of the oldest conventions passed by the UNCITRAL in 1980, but hardly countries are parties to it because, of course, UN system requires, unlike many other countries, allows countries to frame the laws according to their requirements. We also have Sale of Goods Act. I mentioned earlier in the general conversation that there are countries with different sort of a approach to sale of goods. For example, if you're talking about Greece, talking about United States, American Arbitration Association, the local Athens Arbitration Association, all these have their rules, but at the same time, they all adhere to some of the basic principles. So I think this is where I think future lies. But one last point before I end is there is always this problem in arbitration mediation, though it is gaining currency. There is always this problem of the the bargaining elements of parties, because it depends on, this is what I've seen in the last so many years of my work, both in the ministry or elsewhere, and also coming back to academics. The one important problem is it's the parties, where parties are located, which will decide their importance as well. How do they argue it out? Because parties, for example, I have seen arbitration agreements which Government of India concluded many years ago on defense contract, etc., were actually not negotiated for various reasons by parties, because one party located in one of the Western countries might not actually not do anything, keep quiet for a very long time. But all that has changed in the last 20 years, because this is a very important point. So that's why I think it is very important for countries like India and located in Asia or even in Africa. Some of these parties are actually the bargaining of the parties depends upon the kind of contract you are going to have with the company, which can actually create number of problems for you. And this is almost true now, because there are, you can see that the international trade and the international trade agreements, as you can see, is dominated by few countries, few companies, particularly on virtual internet modes, And most of these companies, I don't have to mention globally, some of these big companies, actually, the way they work, I'm sure in recent times, the American Senate Committee had to call 5 of the big virtual companies and ask them all kinds of questions. I think that's the where you have a very, very serious problem relating to how these companies operate, because arbitration, as rightly put by my colleague Kumar Abhijit, I think arbitration clauses are quite tricky, and then the way they put it, we don't read them, because particularly in the internet times, agreement, the definition of agreement in writing has actually changed, and you don't read the agreement in writing as it comes in your internet and etc. Because these are actually, we take it as just one click, we agree, and then we go forward. But of course, companies will have to look at it, and then it's a pretty complex. In case if there is an international contract, I'm sure a big endeavor, like completing a big building in some place, even including in India, I'm sure there will be 10, 15, 20 companies will be working in order to finish a very big project. I'm sure you will have a plethora of arbitration complex agreements with different jurisdiction, with different sort of clauses, and then all these have to be worked out. And of course, applicability of law, applicable law, and then of course the issue of the place of arbitration, both actually present a huge sort of a challenge to everybody. I think today it's a good grounding for students to start with. I think I must compliment Delhi University Law Faculty, Law Center 2, and also I think it's the advocates, Puri, who have actually installed this very, very important on an important area, arbitration Moot, which actually will help students in developing their skills in understanding various laws, various procedures, and also to argue it out. I think they have done it excellently in the last 1.5 hours, despite, of course, all these virtual problems. And also, I must thank Honorable Justice Pratibha Singh for conducting it so well, and also giving us an opportunity to work with her. Thank you very much to all of you.
Thank you so much, sir, for sharing some of your experiences with us and your valuable thoughts. Thank you. Our third guest of honor is Senior Advocate Mr. Rakesh Khanna, former President of the Supreme Court Bar Association. He was also the Additional Solicitor General for the State of Punjab at the Supreme Court of India till 2017. In his illustrious 38 years of legal practice, Sir has represented many government and private bodies in various litigations. We are extremely honored to have you with us today, sir. I would request you to share some of your experiences with us.
Thank you very much. Honorable Madam Justice Pratibha M. Singh, Judge, Delhi High Court, Professor V.G. Hegde from Jawaharlal Nehru University, Dr. Kumar Abhijit, Legal Officer, Ministry of External Affairs, Professor Mahavir Singh Kalon, Professor in charge of Law Center 2, my friend Gaurav Puri, my friend Sachin Puri, Senior Advocate, Professor Pinky, the spirit behind this program, and Professor Obi Lal, whom I had the opportunity of being taught in Law Center 2. For me, I'm grateful to the organizers for inviting me to this very good program organized by them. As a student of Law Center 2, an alumni, it's always a wonderful experience to go back to your college. The moment you join the students of Law Center 2 or any program of Law Center 2, I feel that I have gone back to the college and got my college days. Thanks for all this. Now, arbitration, or for that matter, alternative dispute resolution, is fast becoming the order of the day. It's a wonderful idea by Sachin and Gaurav and the organizing committee to have a moot court on arbitration. Let me tell you, besides, you see, this is a very good exposure for the students to the field of arbitration, which is fast becoming one of the most wanted alternative dispute redressal forum. I find this virtual moot has also given opportunity of destroying the barriers of distance. This will be an opportunity for many other colleges from across the country to join the moot court, and that will that will give more opportunity to the student across the country to such moots and exposure to the field. Another thing which I found, the organizers of this program, the students who have been conducting this virtual moot court, have done a wonderful job, and there were no glitches, which many a time, just as Pratibha Singh will agree with me, we are facing in the court many glitches in the virtual, but in this I found there was no glitch. So all compliments to all of you for organizing this. This also is a very good exposure to the students how to conduct your virtual hearings, especially now when we are in a pandemic, and which will take some time. In fact, the other day when we were discussing, Justice Chandachud was of the view that even after the pandemic is over, and many of the judges are endorsing this view, I don't know, Justice Pratibha Singh will agree with me. Even after the pandemic is over, the judges do feel that many of the cases can be very effectively conducted by virtual mode of hearings. In fact, I'll share with you another very good experience which I had. A boy called Rahul, he is from Dehradun Petroleum Law University. During this pandemic, he started conducting, for Youth Bar Association, the virtual webinars. And we conducted a webinar and with Youth Bar and Supreme Court mediators. And I was very happy that he could handle a webinar in which there were 2,500 participants. And when he had put the video on the YouTube, we had 28,000 viewers on that. So that is the goodness of the virtual program, that once it comes on the YouTube, even thereafter, people can get benefited from the experience and the webinars. Coming now to the issues, the alternative dispute redressal form, disputes resolution is fast becoming an order of the day. Not only arbitration, as I was discussing during the interregnum period after the competition and before we started this program, mediation also is fast becoming order of the day world over. And especially in many countries, we are having the pre-litigation mediation. And many a times it has been observed that the pre-litigation mediation becomes very successful, and that reduces the expenses, the time consumed in the litigation, and it is a very good experience for the parties. In fact, in many countries, they have brought in legislations to adopt pre-litigation mediation as a mandatory process. In India also, in the commercial litigation under the Commercial Act, we have made it mandatory now to have pre-litigation mediation. In fact, under the auspicious of the Supreme Court, my Lord Justice Call had worked on this framing of legislation on mediation in India, and His Lordship constituted a committee, and a committee has prepared a draft legislation which has been now being discussed in Niti Aayog, and there is every likelihood of the India getting a mediation legislation. In fact, I was suggesting, Mr. Puri, that fast, when mediation is taking over the field, the next Moot competition, they can think over on mediation, on pre-litigation mediation. Coming to the arbitration, arbitration in itself is a very good process, a very good alternative dispute resolution mode. And it is seen that parties during the arbitration and in the arbitration, which is an informal process, where you see the arbitrators are not strictly bound by the procedural technicalities, are at times able to get very good results, and especially now under the amended Act, Arbitration and Conciliation Act, the time-bound results. And further, it also reduces the scope of further litigation in the court. So I think with little more modification of the Arbitration Act, if we can make arbitration in India as institutionalized arbitration. In fact, when I was Additional Solicitor General of India, the Law Ministry undertook the exercise, and the discussions took place all over the India. And one of the major thing which was coming during those discussions was that we can have institutionalized arbitration, which is lacking in India. Of course, our Delhi High Court, High Court International Mediation Center is one of the very good institutionalized mediation center, but we need to bring it in the legislation and make the arbitration process in India more institutionalized, which will, I believe, yield better results and will give more authenticity and credibility to the arbitration process. I think the organizers and the committee and Mr. Puri, both Gaurav and Sachin, need to be complimented. And the Law Center, Professor Pinky, and the students who have organized this competition deserves to be complimented. Thank you very much.
Thank you so much, sir, for your words of wisdom and the encouragement. With great pride, honor, and joy, we now welcome Honorable Justice Pratibha M. Singh, Judge of the Delhi High Court, as our chief guest for today's event. Justice Singh is considered as one of India's leading IP litigators. She has argued and handled a large number of IP cases in India, many of which are today considered as the landmark cases. She has also written on the intersection between intellectual property and the ongoing pandemic, and her work have been recently published in the Hindu newspaper titled Needed, a Pandemic Patent Tool. In 2013, Justice Singh was designated as a senior advocate by the Delhi High Court, the first intellectual property practitioner to have been ever elevated to this role. 4 years on, and in May 2017, ma'am was elevated as the judge of the Delhi High Court, becoming the Justice Pratibha M. Singh. It is a moment of extreme pride and privilege for Law Center 2 to have such a dignitary with us today. Ma'am, I would request you to kindly enlighten us with your words of wisdom.
Thank you, and a very good morning and afternoon, because we've been here for a number of hours now. Mr. Khanna, colleague from the bar, Professor Hegde, Dr. Abhijit, my illustrious co-panelists and the co-judges today on the Arbitral Tribunal, Dr. Pinky Sharma, Dr. Mahavir from the Law Center 2, all the students who are participating and the organizing committee, and above all, Sachin and Gaurav, again colleagues from the bar. It was an absolute pleasure to participate in this moot court today and to be called as Madam Arbitrator, Miss Arbitrator, and it was really nice how I think the students were struggling to think about how to address the bench today because they didn't know, and I found that quite innocent and nice. I must say that. I must start by saying that Mr. S.K. Puri, the father in whose name the Moot Court has been organized, was a prominent face in the High Court lobby right from the time when I entered the Delhi High Court since 1992. And we always used to see Puri Sahib in the High Court regularly. And of course, Sachin and Gaurav joined him later. And it's an excellent initiative that the family has taken to organize a Moot Court for their being alumni of the Delhi University and giving a platform for all these youngsters. I would like to congratulate both the organizers and the brothers for this wonderful event. See, always organizing a moot is very, very difficult, but organizing it during a pandemic is even more difficult. And I think you've done a commendable job. You need to pat yourselves at the back for doing it so wonderfully and so seamlessly today. And we didn't find any single glitch, as Rakeshji was saying, and I think that's a huge credit to the organizers today. There are certain important features of this moot court which are different from others, and I would like to highlight that today because I do judge a large number of moot courts regularly, but I like the fact that the problem is very simple. It's a simple sale transaction because most moot court problems become so complex and they're so detached from the real world. This is a real problem with a real world connect. And I really like that it's a simple problem. Students will be facing sale transactions of this nature on a daily basis. You know, despite the fact that, as Professor Egede said, that we haven't ratified the United Nations Convention on the Sale of Goods, but our provisions are very, very similar, either under the Sale of Goods Act or under the Contract Act. So it's not very different. Our laws are the same, direct and indirect damages, you know, the same kind of issues as to foreseeability of damages. All the principles are the same, and therefore it's a very nicely put, simple sale transaction problem, and I really like that. I like the fact that you have a backdrop, which unfortunately I didn't get, otherwise I would have put it up for myself behind me, and that's a nice feature. The third thing that I liked was the score sheet. And in the score sheet, what I liked was the last column relating to the researcher. You know, in every moot court, the researcher never gets a chance to speak. And a researcher speaking in this moot, I thought was a wonderful initiative. And that was a very good surprise. And I really liked that feature as well. And two things about the students themselves who presented today. One, I like the fact that they confidently shared screen during the hearing, which was very nice, which is how lawyers do it today. And in a COVID situation, that's the way to go about it. And I really like the researcher who picked such wonderful small mistakes in the other moot court memorials, you know. So that's the creativity which the children are showing today. And I really like that the students have been good spirited. They're all full of smiles, and despite sitting in their own little rooms, they're still having the enthusiasm to participate. I just want you to rewind back to 1989, almost 31 years ago. That's when I participated in the JESA. Can you all imagine doing a moot court without the internet and without a computer? It is actually impossible. I wonder how we did it then. It's just, we had to actually electronic type our memorial to send it to the JESA. And at that time, the moot court used to be held in Pondicherry for the national selections. And all the teams would assemble in the Pondicherry Law College. It used to be like a festival. We used to love it. And the All India, selection used to happen there. So we were, I belonged to the University Law College, Bangalore. We were an all three girls team, and all of us. In fact, the Bombay GLC team was also two girls. So we were 5 girls representing India at that time in 1989 who went to Chicago. And it was a very, very tough process. We used to have a lot of financial problems as well in mooting. And I see that 30 years down the line, our students still today face problems to go for international moots. And I think, therefore, at every Moot where I speak, I think the time has come to create an All India Moot Court Fund where all students, any team, irrespective of whichever team it is able to, not run around for finances, whether they get selected for JESA, whether it's Moot, whether it's the, I know all the important Oxford IP Moot or the environmental law Moot, so many of them. Whichever teams get selected from India, we should make it so easy for them to get funds. And I think there's a need to create an All India Moot Court Fund at this point, because students even today struggle for getting funding, whether they are from the national law schools or from DU. I'm very, very sure about it, that it is very difficult to organize or to, take part in moot courts. So I really think that you've had a wonderful competition today, and I'm very happy that Gaurav gave us the numbers where he said that 32 teams are registered, 24 participated, more than 60 judges took part. And I received the email of the memorial from Dr. Pinky Sharma at maybe 10:30 in the night yesterday. And I woke up and then read them in the morning. So I can imagine it must have been a very, very tough process to get this moot and put this together. 3 or 4 tips, apart from what all my illustrious co-judges have already given you. First of all, it's very important to be innovative and be creative. And I think that the tip which Dr. Abhijit gave you about, you don't need to depend for everything on the facts. When the judge is giving you an opportunity to think out of the box, do think out of the box. Okay? So you don't have to when you reach the finals especially, we really expect you to have a lot of creative and innovative thinking at the presentation. So the other thing that I would say is you could have a little bit of humor, and you don't have to be so serious when you present in the moot court. I like the presenters who have their own, happy faces, and it's not necessary. That just shows that you're not stage. You don't have stage fear or any of that kind of complexes. And you must be very confident when you speak, which I found all the speakers today were very, very confident. Your research has to be immaculate. You cannot make typing errors in your memorials. These are all the small things that judges do notice. Don't think judges don't notice that. We can, all the judges here, I'm sure when we open the memorials, we can make out on which page, which mistake you've made. So you'll lose marks if you do that. So these are all the little tips that I would like to give about mooting. And lastly, I would like to, I'm sure all your career counselors, etc., do give you tips about what are all the career options for lawyers, etc. But I must say that law has become a very sought after profession today. It's not how it was when I joined law. I wanted to be a doctor. I never wanted to be a lawyer. But I landed up being a lawyer because one couldn't always pursue the career of your choice for various economic and family reasons as well. But today, I know of students who've given up a seat in BITS Pilani or even in AFMC Pune to join law. So today, law is like equal to an MBA or an IIM or something. And I think all of you, especially girls, it is very difficult for your families to allow you to practice law. And I'm sure all of you have had your struggles within your families. But I just wish to highlight the kind of career options that are available for lawyers, just so that you can keep in mind and see what all are your options. We all know that you can become corporate lawyers, you can become litigation lawyers by going to courts. But I think that one of the biggest career option for lawyers today and law students is academics. And I would really think the better teachers that we have in law, the better the law students will get trained. So academics is an excellent option. The next option I really think is very exciting is legal journalism. And you will see the large number of websites and newspapers who employ legal journalists. You can actually write about law and still be, employed in not in a court stressful environment, but still be quite challenging. You can become legal managers in either the private sector or in the government service, as I can see Mr. Abhijit is today. And the next career option I would suggest for lawyers is policy bodies. Like, for example, Niti Aayog, CPAM, Vidhi, Samvad, all of these policy bodies who are doing an excellent job in supporting the litigation system. They come out with reports, they come out with reports for legislators. Like, I don't know if you've heard of the PRS legislative body, which supports lawmakers like members of parliament and legislators to create reports on laws. So all these policy making bodies themselves have a very important role to play in the legal system. They do data analytics, they employ artificial intelligence for legal research, legal publishing, like all the websites and for example, the Legal Quest platform, which has now come up. And then judiciary, on the academic committee and the judiciary examination committee of the High Court, I noticed that in the last 2 or 3 years, more than 60% of the first entry level judges of our courts in Delhi are girls. You would be very surprised. 60% of the sub-judges, munsifs, magistrates, they are girls. So immediately after doing law, you can actually give your judiciary exams and enter the judicial stream. And then you have your promotion avenues. Then if you learn a foreign language like French, German, Spanish, or any of those foreign languages, in addition to English, you can actually work in various United Nations bodies, international institutions who have law as their basis. And finally, even if you decide to join practice, it is very good to specialize in laws, whether it's competition law, whether it's IP law, whether it's taxation, whether it's international trade law, commercial laws, arbitration, mediation. So I think the avenues for lawyers have really, really opened up. And I think all of you have a wonderful future ahead of you. And the fact that you're all able to come and present your cases here, I think it was a very tough choice. The teams did very well. The fact that you reached the finals is itself a very big attempt. And, I really want to compliment the team from Jammu who took so much effort to go to Udhampur and to present their arguments, maybe due to internet connectivity or whatever. That shows their commitment to the legal field. So therefore, all of you sitting at home or wherever you are in your universities or in your colleges, the fact that you're participating, it's a commendable job. And it's, I would like to compliment the Faculty of Law, Law Center 2, for organizing this. And finally, definitely the organizers for, giving the emotional, the infrastructural, and the financial support for organizing this moot court. Thank you for having me here. And I wish all the best to all of you today. Thank you very much.
Thank you so much, ma'am, for your inspirational and encouraging words. It is actually a privilege to hear you and your valuable thoughts. This brings us to the end of our 4-day moot court competition. I would really like to request Professor Dr. Mahavir Singh Kalon, the professor in charge of Law Center 2, to kindly deliver the vote of thanks.
Thank you. Am I audible?
Yes. Yes, sir.
Okay. Thank you. Honorable Madam Justice Pratibha M. Singh, Delhi High Court. Mr. Rakesh Khannaji, Senior Advocate, Supreme Court. Professor B.G. Hegdeji, Jawaharlal Nehru University, Delhi. Dr. Kumar Abhijit. Mr. Sachin Puri, the faculty members, the participating teams, and my dear students. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of Law Center 2, Faculty of Law, University of Delhi, first of all, extend my heartfelt thanks to our chief guest, Honorable Madam Justice Pratibha M. Singh. for gracing the occasion with her presence and sharing her thoughts and finding with our audience. Today, I don't hesitate to say that in past also, as and when we requested Honorable Madam always pleased to oblige us to be part of our Law Center too. And today, ma'am, you for sharing your experience, including experience as student 31 years back. I'm really thankful to you. Lot of thanks, madam, for becoming the part of this event. I'm also thankful, Mr. Rakesh Khannaji, Senior Advocate of Supreme Court, and I am extremely delighted and glad to know that you had been the student of our Law Center 2, and I feel proud to have you here. Thank you, sir, for becoming a part of this event, and thank you for sharing your good experience with our students and with our participants. Professor V.G. Hegedeji, who is so renowned professor and international jurist from Jawaharlal Nehru University, New Delhi. Sir, I'm also equally thankful to you, also extremely thankful to you also for honoring our invitation and taking out time from your busy schedule. Dr. Abhijit Ji also, I'm going to honor, and I'm feeling honoring that our invitation and taking out time from your busy schedule to be a part of this valedictory ceremony. A big thanks to Mr. Sachin Puri, son of late Sri S.K. Puri, for extending his unstinted support to all of us at Law Center 2 in the successful organization of this moot court competition. I would also like to express a very hearty vote of thanks to our dignitaries for the inaugural ceremony of the moot court competition. Honorable Mr. Justice of Allahabad High Court, Ataur Rahman Masoodi ji, Professor Vijendra Kumar, Vice Chancellor of Maharashtra National University, Nagpur, and Professor Nujat Parveen Khan, former Dean of Jamia Millia Ismailia, for their valuable time and consideration. I would also like to acknowledge my gratitude to all the judges for the various rounds of the competition, for spending their valuable time and making this competition reach its conclusion. This year, as all of you know, due to the outbreak of coronavirus pandemic, the 4-day event was conducted in a virtual mode, and we are proud to be one of the first institutions who have been able to successfully conclude our moot court competition virtually. This would not have been possible without the tireless efforts of organizing committee, and I would like to extend my sincere thanks for Dr. Pinky Sharma, the convener of the organizing committee, and other teacher members of the committee, Sumiti Ahuja, Dr. Naresh Mahipal, Dr. Pramod Tiwari, Dr. Monica Chaudhary, and all students, including all court masters, volunteers for making this annual event a grand success. And special thanks to the students Abhishek, Ruchika, Ritika, Sudeep, Rishi, Pankaj, Shreya, Simridhi, etc. So I'm really thankful all of you. Here, this virtual event would not have been possible without the efforts of the technical team. So I would really like to thank Dr. Ajay Sonivanaji, Assistant Professor, Law Center 2, and his team for providing the technical support throughout the competition. I would also like to extend my sincere thanks to Mr. Praveen Sharma, advocate from Mr. Puri's office, from his constant support throughout the event. Last but not the least, thank you to our lovely audience who joined us through various social media platforms. The event would have not been possible without you all. I'm very thankful to my all colleagues, not only who supported and cooperated, but also joined this event for making it a successful event. And I, pay my thanks to my senior colleagues, Professor Kim Gupta ji, Dr. Anupam ji, and other colleagues also who joined this program. And I'm really delighted for this successful event. And I congratulate entire faculty members or the entire, you could say, the family of Law Center 2, as well as our, Mr. Sachin Puri ji, who had been always, supporting tool for our Law Center 2. So I'm really thankful all of you. And again, I congratulate all of you for making this grand success. Thank you. Thank you.
Thank you so much, sir. I think sir really forgot to mention one very important person, and that is sir himself. I would really like to thank you, sir, for being a constant source of encouragement and for your support. So on behalf of the whole committee, I would really like to thank you.
Thank you. Thank you.
Now, moving ahead, I would like to invite Mr. Soumitra, the student of Law Center 2, to conclude the program with the national anthem.
Are you not announcing the prizes?
Jaya
Thank you, Soumitra. I'm so sorry, ma'am, I could not reply you at the moment. We will just announce the results. And with your due permission, Honorable Justice Pratibha M. Singh, I would like to request Mr. Sachin Puri to declare the much awaited results of the finals.
First of all, thank you, ma'am, for allowing me to announce the results. And just one line I would say before I announce the results. Ma'am, it has been our endeavor to bring this moot court closer to the court proceedings to give some sort of actual sense to the students, and rather than taking it away from the debating portion of the moots. And the way, ma'am, you led to conduct the court today, it was as if the actual case was being argued before you, and I have that experience and I can say so, having been argued the matters before you even on BC, ma'am. It was wonderful experience. At least I got a wonderful experience, and I'm sure the kids would have. Now for the results, the first announcement is for the second best memorial, which is a cash prize of rupees 20,000, which goes to the team code J2032, that is Faculty of Law, Jamia Millia Islamia. The best memorial, that is cash prize of rupees 25,000, is being awarded to team code number 2006, that is Symbiosis Law School, Pune. The second best researcher, that's a cash prize of rupees 10,000 rupees, is awarded to a team from J2002, the researcher's name being Miss Astha Shukla, Campus Law Center, Faculty of Law, University of Delhi. The best researcher award is for team J2008, cash prize of rupees 15,000, Mr. Ishan Nirti, National Law University, Delhi. The second best speaker, and this is interesting this time because the best and the second best speakers also come from the two finalists. The second best speaker, that's a cash prize of rupees 10,000, is awarded to the team code number 2028, Ms. Kavya Agarwal, Jindal Global Law School, Sonipat. The best speaker, that's a cash award of rupees 15,000, goes to team J2005, that is Mr. Udit Anshu Singh, Symbiosis Law School, Noida. And as I've been given to understand, and ma'am has announced, that this was a very closely contested final, and one has to come out as a winner and one as a runners-up. The runners-up team, that is cash award of rupees 35,000, goes to Symbiosis Law School, Noida. That means the winning team with cash prize of rupees 50,000 is Jindal Global Law School, Sonipat. Congratulations to all. Ma'am, there has been a long tradition that we request our chief guest in time to come if a subject for the next moot court could be provided from the chief guest of the function. So ma'am, if you don't mind, we'll get in touch with you in due course to take a subject from you and share our thoughts.
Sure. Heartiest congratulations to Jindal and to Symbiosis. Both of you did extremely well, and well done, and keep up the spirits. Sachin, you can contact me. I'll give it to you. No problem.
Thank you, ma'am. Thank you. Thank you, everyone.
Thank you so much. Congratulations to all the participants and winners. We are really sorry that in these unfortunate times we cannot felicitate you personally, but all the wishes of the organizing committee are with you all. So thank you so much. Thank you, everyone. Thank you for joining.
Thank you.